Yes.
May it please your lordship. My lord, item number 125 of part 2 hearing this. This matter may be taken up on Thursday, my lord. There is an order. Kindly produce. There is an
No,
order.
this matter is not assigned to me. Part 2 list, dear Nainama. We have not been given. You just do one thing. You just ask your junior to give an application to the court.
Fine.
Say this court has permitted. Thursday it will come. I'll hear.
Fine. Problem.
Milord, in item 57, Milord, we have filed a review petition of the last order, Milord. If can it be taken up today along with the item 57, Milord?
Last order?
Last order passed by your lordship, Milord. The learned AG appeared in this case. And we recorded, in fact, your lordship dictated the order recording our objection to bringing filing a new affidavit, my lord. But for some reason, I don't know for what, this is not reflected in the order last passed.
It's not there.
Not there.
Okay.
Maybe it may be an inadvertent error on.
I know it. Even without the review, we will consider it.
In item number 57, my lord lordship, we have filed our reply today, lordship. That record may be called for lordship. If you apply.
Have you served a copy?
Yes, they have given.
May I please your lordship. Item number 8, lordship. In this case, I seek some instruction from my client, lordship. Let it come after 2 weeks.
Huh?
Item number 8, lordship.
Huh.
I need some instruction from my client, lordship.
What instruction?
Regarding lordship, date of joining.
That was something which should have been there when you filed the
Lordship.
petition. It's not there.
2 weeks, lordship.
On the prayer of Mr. A. Sharma, learned counsel for the petitioner, registered to list the matter again after 3 weeks on a date to be fixed by it.
May please your lordship, I beg to mention item 56 of today's list, my lord. We require to file affidavit in opposition. We have already informed the other side also, my lord.
But you have been taking time.
Yes, my lord.
This, I think, is the 3rd day or 4th day.
Yes, my last time I will give you.
Ms. A. Gayan, learned counsel, learned CGC, appearing for the respondent, submits that the instructions in the matter is yet to be received by her and accordingly prays that the matter be taken up
After 4 weeks, my lord.
after 4 weeks. She undertakes that an affidavit on behalf of the respondents represented by her would be filed before the
Yes, ma'am.
date of list.
Master bless.
May I please.
So prayer accepted, registered to list this matter again after 4 weeks on a date.
Master bless.
I beg to mention for withdrawal.
All mentioned matters given, she will give the date.
May I
May
please.
please.
Yes, Mr.
May I please, Lordship? With the consent of Authorised, we have already circulated in respect to item number 58, Lordship. We will file our affidavit during the course of the day, Lordship.
Mr. K. Kolita.
For respondent 1 and 2, Lordship.
Learned counsel appearing for the respondent number 1 and 2 submits that an affidavit on behalf of the respondents represented by him would be filed during the course of the day. Accordingly, he prays that the matter be taken up after.
May I lordship? Any date apart from 2nd week of August and 17th?
Taken up on 24/8/2026. The petitioners are at liberty to file a rejoinder to the affidavit that would now be filed by the respondent before the next date of listing.
Lordship, another prayer in respect to item number 51, though the matter was at the instance of the petitioners, the matter is listed, Lordship. We have received records, Lordship. Lordship, I have not gone through the records. Lordship may have the matter on 6th of August.
What happened to his criminal case?
Is pending, Lordship.
Charge sheet filed.
I have to check, Lordship.
Have you informed the?
Yes. On 6th of August, Lordship. We have received a record, Lordship.
Mr. K. Kolita, learned counsel, appearing for the respondents, submits that the records in the matter has already been received. However, he could not peruse these things. He prays that the matter be taken up on 6/8/2026 for hearing. First off, there is no objection. First off, it is also further submitted that the prayer for adjournment is made with the consent of the learned counsel for the petition. So accordingly, registered to list this matter again on 6/8/2026.
Hello, please.
May please your lordship. Lordship, I beg to mention supplementary list 54. We have filed our affidavit in opposition today, lordship. Kindly.
Which one?
supplementary list item number 54.
Item number?
54, Lordship.
Call it.
Obliged Lordship. May I please, your Lordship? I beg to mention item 52, Lordship.
Hmm.
52, Lordship. I may be allowed to withdraw, Lordship. Actually, they have some technical error, Lordship. So, with a liberty to file a face, Lordship.
Mr.
GG
GG Gugui, Learned Counsel for the petitioner, submits that certain inadvertent errors have occasioned in the writ petition, which would require to be rectified, and accordingly he prays that he be permitted to withdraw the present writ petition and refile the same after rectifying the errors. Prayer is not objected to by the learned counsel for the respondents. Full stop. Accordingly, the present writ petition stands dismissed on withdrawal.
Master.
May it please, my lord, with due consent from the other side, I beg to mention item 46, my lord.
46.
I'm appearing on behalf of Mr. PJ Fukon, standing counsel for Gauhati University.
Yes, why?
Lord, I humbly pray that the matter may be accommodated for a week. My senior, he has some personal.
This is only for issuance of notice. We'll issue notice today. Mr.
Could not
Das is
appear
there, we'll
today.
issue notice. He has raised a plea. We'll have to answer that. Why delay the matter? Your senior is not here. We are not disposing it of today. We'll only be issuing a notice, right? Mr. Das, we'll record your name. You need not be here. We'll issue a notice because it's in a very narrow compass. You say that this court had passed the order on the basis of the instructions given by the controller. If that is erroneous, then we will take care. Let them have an opportunity to counter that. That's all. Was the result of the other petitioner declared? You need not be here. Your junior can be here. Well, I'll record your name. Yes.
No, I may be allowed to withdraw this petition with the liberty to file it so required.
Huh?
I may be allowed to withdraw the petition with the leave to file if so required.
With the leave to file what? Mr. Dasgupta, this conditions you have yourself undertaken to follow. You were a state doctor. You got a quota in the state quota. So how can we give, why should we give you a liberty? And you are neither working nor you have paid up the amount. So it's against public interest now. You have been trained. You withdraw, I'll permit you to withdraw. Mr. A. Dasgupta, Learned Senior Counsel. Heard Mr. A. Dasgupta, Learned Senior Counsel, assisted by Ms. B. Das, Learned Counsel for the petitioner. Also heard Mr. D.P. Vora, Learned Standing Counsel, Health and Family Welfare Department, and you are also appearing.
No.
Also, Mr. Dasgupta on instructions have submitted that the petitioner desires not to press the matter any further. Accordingly, he prays that the matter be dismissed as, he prays that the matter be permitted to be withdrawn. Prayer accepted. The present writ petition stands dismissed on withdrawal.
Obliged.
For instruction. If the petitioner is an worker, helper in an Anganwadi work center, my lord, he is facing some difficulties to discharge her duties, my lord, because of the husband of the worker.
You're working still now.
Working, my lord, I am unable to regularly attend in the center, my lord.
Yes, who is appearing
Because
for
of
the
harassment, my
respondents?
lord.
None, heard Mr.
Your Lordship, in this matter, Your Lordship, Pavitra Saikia, government advocate is appearing. Your
But
Lordship.
he is not here.
Your Lordship may take it up after some time, Your Lordship. Maybe he has received some instructions.
If he has not received, we will have the director because 1 month, more than 1 month.
Yes, Your Lordship, I understand.
Obliged.
Lordship, here Mr. Sekes Borua is appearing in this matter.
No, the
After some time.
inquiry report has been given, the interim order passed earlier has been vacated. Now what is left here?
Lordship, I have not gone through this
No,
because
you need not. Let's wait for the petitioner. If they come, we'll see.
Please, your lordship. The petitioner retired from service on super.
When was the recovery made?
Discovery was at the time.
Recovery already made.
Yeah, already made.
Heard Ms. S. Bora, learned counsel for the petition. Also heard Mr. H. Gupta, learned CGC appearing for the respondents. The petitioner in the present writ petition has prayed for a direction upon the respondent authorities to refund to him the amount deducted from his pension and pensionary benefits on account of a refixation of his pay and allowances. Also, the petitioner submits that he is in no way responsible for the earlier erroneous fixing of his pay and allowances, and accordingly, upon the superannuation from his services, the said amount was not permissible to be so withdrawn from, recovered from his pension and pensionary benefits. Also, issue notice, returnable 4 weeks. Mr. Gupta accepts notice on behalf of all the respondents. No formal notice is to so and so, so and so. Also, it is provided that the recovery affected from the pension and pensionary benefits of the petitioner shall be subject to the outcome of the present writ petition. Registry to list this matter again after 4 weeks on a date to be fixed by. Pleasure.
may please Lordship. Lordship, I am agreed by an order of suspension. Suit in my favor, my lord. Lordship will find the order at page 63.
Yes, what is this happening?
My lord, there's been a suspension order, my lord.
Huh?
Yes.
No, we are not, the suspension order itself is not sustainable. The order posting him to Karbi Anglong
My lord.
was already stayed by this
My
court.
lord, that has been
Then-
stayed. Well, the attachment was stayed, my lord.
Did it as it, but then for his non-working in Karbi Anglong,
But
how
this-
can you?
My lord, about that, let me take the instructions because, my lord, it seems that it might have been prior to that. Let me just take the instructions.
5/6/26. The
Well-
order of this court is
My lord, the High Court order is on 8/4/26.
8/4/26.
Page 51.
And this man has been dealt with in a bad manner. We are, from the materials,
My lord, may
good
take this-
vibes are not coming.
My lord, let me take the instructions, my lord, a short date might be granted.
On the prayer of Mr.
RB Goswami,
R.B. Goswami, learned counsel, learned standing counsel,
transport.
Transport Department,
Transport.
registry to list this matter again on Wednesday
Hello.
to facilitate Mr. Goswami to complete his instructions of the matter. Wednesday date to delivery. Huh? Also, registry accordingly to list this matter again on 29/7/2026. Let's
Deeply obliged.
All right.
May please, your lordship. Lordship, I am appearing on behalf of Mr. P. Bodler in this matter, your lordship. Lordship, this matter has become infructuous, your lordship.
This is an earlier
Yes,
round of.
yes, your lord. That was withdrawn and then subsequently another order was.
Mr.
KJ Sekhe.
KJ Soikia, learned counsel for the petitioner, submits that the order impugned in the present writ petition was subsequently withdrawn by the petition, by the respondent authorities on that earlier round of litigation. It was withdrawn. There was an order. What was that order?
That
Dated?
order is, it is there in the other petition, your
Ah.
lordship.
What was the
Lordship may
date?
produce this order, your lordship, that was
that-
passed in that.
Was withdrawn. Also,
Infructuous.
thereafter,
Was withdrawn by the order. that 25
fresh order dated 4/7/2026 was issued, terminating the services of the petitioner, which has been challenged by the petitioner by way of instituting a writ petition being WPC number 3682/2026. Puso. Accordingly, Mr. Saikia submits that the present writ petition has been rendered infructuous. Puso. Prayer is not objected to by the learned counsel for the respondents. Puso. In view of the above, the present writ petition stands dismissed on being rendered infructuous.
Deeply obliged.
The matter may be passed over for the time being.
Why?
Ardhor is in lakes.
Huh?
Ardhor, PWD, his standing counsel is in court number 10.
He has got his instructions.
Perceive might be.
After- Yes, Mr. Gugwe.
The petitioner initially appointed as a senior.
Huh?
Petitioner initially appointed as senior scientific assistant.
We have heard it last date. We have asked you some queries. What is your reply?
The queries, I have filed an additional affidavit
Hmm.
regarding the last order, dated 5/9/2025.
Hmm.
Before that, we file an writ petition regarding there is a selection process, embarrassment, which was set aside by the this court.
Where is that order?
The order is at lordship 104, it's at 104. Regarding the deputy director and joint director. We start from 104. And the authority begins from the 113, page 113. The
WPC 904.
113, lordship.
Huh?
Page 113,
113.
additional affidavit.
Okay, 113, yes.
In that case, we have challenged the.
Oh, I had appeared.
Yes, lordship, on that case, my lord
No,
also
no.
appeared.
Well, did I appear for this petition? No.
Not for the petitioner, but my lord appeared in case number 3931 and 17.
How is this petition? Now tell me one thing. You are now
Brother-
aspiring for promotion as deputy director.
Yes.
How many persons are there who are in the feeder cadre?
Did I get that?
You are aspiring for what? Which post? Joint director.
Now
Joint.
joint director.
Joint director. How many posts of joint director are there?
Nine posts of joint director there.
How many is filled up?
Only 4 is there. Lordship.
Rest are filled up.
The rest,
Nine
filled.
posts. Joint director,
Lordship,
9
seven.
posts.
Yes, lordship.
Man in position,
Man in position 4. I have filed my application.
and vacancy 5.
Vacancy 5. In the director.
How many deputy directors are there?
Deputy director, sir, lordship. Now the deputy director fill up,
Huh?
lordship.
How many cadre?
Deputy director, lordship,
And what is the criteria for promotion as deputy joint director?
joint director, lordship, as per rule 28 from the deputy director to joint director. After attaining the required criteria 5 years as a deputy director. And there is a provision for relaxation of the criteria also there. Rule
That
28
is it. Yes, Mr.
Rule 28 also there, lordship.
Forget his delayed promotions and all. Now, there are 5 vacant posts of joint director.
Hmm.
And now the division thing does not come. From joint director onwards, it's everybody every deputy director is eligible.
Eligible.
And the others have also not completed 5 years.
Not completed.
So have your instructions. Why no? Where these posts are kept vacant, use your power for relaxation, give it to them.
Because otherwise it is.
We'll not
vacant.
go into the delay, the promotions, delayed promotions, because that will now have the effect of unsettling a settled position.
Yes.
We'll not go into that. But here,
Yes,
he
yes,
gets it or not, that's a different thing. But the deputy director cadre is full. So there are persons in the feeder cadre. 5 posts admittedly is vacant, and only way of recruitment is promotion. Consider it. Heard Mr. N.J. Gogoi, Learned Counsel for the petition. Also heard Mr. T. Pora, Learned Government Advocate appearing for the state respondents. Mr. Gogoi submits that presently there are 5 vacant posts of joint director available, and the post figuring in the cadre of joint director is to be filled up by way of promotion from the cadre of deputy director. on the basis of seniority. Also, he submits that although the petitioner has not completed the requisite mandated residency of service in the cadre of deputy director, the respondent authorities are empowered by the provisions empowered under the rules holding the field to relax such requirement in the requirement of residency of service in the rules. Also, Mr. D. Bora, learned counsel for the respondents, government advocate, learned Mr. D. Bora submits that he be granted time till 2 weeks.
2 weeks, Your Lordship.
Till 10/8/2026 to complete his instructions in the matter. Also, prayer accepted, registry to list this matter again on 10/8/2026. Also, on the next date of listing, Mr. Bora shall address this court with regard to the contentions recorded herein above made by the learned counsel for the petitioner.
Oblige, Lordship.
Yes.
Please, Your Lordship.
Yes.
May it please, Your Lordship. Lordship, I pray for a week's time, my lord.
Okay.
Lordship, the new CTPO has joined in this place, my lord. So, my lord.
When did he join?
I think from today he is joining.
So what happened to the earlier one?
Yes, my lord.
Today only. He
Yes,
had passed this order on 17th.
yes, my lord, but
What?
he has been trying to collaborate with the earlier CTPO, my lord. 1 week's time may be given, my lord. He posted on 3rd of August, my lord.
We only wanted as to what is the stage, that's all.
Yes, my lord. But the new CTPO has to issue.
Ms. R.B. Bora submits that in view of the change in the incumbent in the post of Child Development Project Officer, appropriate instructions could not be furnished to her in the matter. She prays that the matter be taken up on 3/8/2026, on which date she shall furnish she shall furnish the requisite instructions with regard to the status of the recruitment exercise initiated for engagement of Anganwadi helper in pursuance to the advertisement dated 18/7/2025.
Lordship, in this matter, my lord, Dhamdhama ICDS project, my lord, item number 12 and item number 13, my lord, this is Musalpur, my lord, ICDS. Is this the same CDPO, my lord?
Same CDPO in Musalpur also.
Item number 13, worker, my lord, applied for work. That instruction, my lord.
Why the instructions are not coming?
Lordship, I think new CDP.
You have not returned to them.
No, my lord, we have written, my lord, and also
why they have not?
verbally communicated.
Ah.
So once actually we have written to the law officer, he has handed over the phone number. So we accordingly we contacted the CDPO, my lord.
Then why is he not filing?
Yes, my lord. Then we came to know that he'll be joining from today.
No, that is in the
Yes,
first
ma'am.
case. Second case.
Second, my lord,
Uh,
this one, my lord.
Lumoni does.
Lordship may have it after some time. I'll confirm which.
After some.
Yes, my lord.
Yes, what is this? 19 were recruited in place of 6
No, Lordship.
ex-servicemen.
Total out of 111 candidates.
No,
Because
for
Lordship-
this
Lordship,
post, this post.
This is third round of litigation, Lordship. Earlier 2 times they have filed, and whenever we place the instruction, they withdraw the petition, Lordship.
That is
Please.
not disclosed in the present petition, is it?
I think they have disclosed regarding withdrawal of the
Uh-huh.
page 74, Lordship. Page 72.
Hmm.
This is notification, Lordship.
Hmm.
As per the DOPTs, notification number says dated so and so, 410 today. Page 72.
72.
10% of vacancies in the post up to the level of assistant commandant in all so forces, 10% of vacancy group C post, and 20% of the vacancies in group D post are reserved for ex-servicemen in central government. Likewise, 14.5
This
vacancies
is
in
not
group
for
C.
you. This
Group-
is not for you.
In terms of this
This is not for you, this is for the armed forces.
Ultimately, PSU, Lordship.
Then,
They, 111 posts, the notification vacancy
no,
is 111.
he is applying for. These petitioners are applying for OSG1 2025, 44 posts.
Instruction
44 posts.
Yes, Lordship.
Now, if that 44 posts, the minimum required to be reserved for ex-servicemen, how much post is out of 44? How much?
111 posts, total 100 prisons.
No. We are concerned with OSG1
Lordship, because
2025.
that notification, if Lordship
No,
comes to
Mr. Kulta, if this is the post he had applied,
yes,
recruitment is against this post because the other posts have different qualifications. So this post, why were they not considered? And why were the posts filled up by ex-servicemen?
this is the advertisement instruction, Lordship. And Lordship may peruse the paragraph 8 of the petition. The petitioner is aware about the implementation of that DOPD 46/2014. So group, if Lordship peruse the advertisement, total post earmark is 111 posts. In respect of group C, Lordship. So
No, did you hold separate selections for all these posts or there was one selection for all the posts?
one selection, Lordship.
One selection.
One selection.
Then a candidate who is applying
Yes.
for this
Because
OSG,
ex-servicemen applied in respect of 4 categories only. Total 16 candidates.
so
were-
they had boiler attendant certificate, this
Yes.
ex-servicemen,
Yes.
they had.
Yes, already 7 candidates joined, Lordship.
No,
Total-
this boiler attendant certificate the persons had.
Lordship.
They also had fire and safety certificate.
Yes,
In addition to having 3 years qualification.
yes, Lord.
All these posts are different posts. How can you have one selection?
But ultimately, sir,
But you have published different select lists.
different select list, but Lordship, if advertisement also, page 27, note 2.
Reservation against particular posts.
Yes.
So reservation against OSG1 2025, you can recruit
Because this is
14.5%, no issue.
14.5% in respect of group C, Lordship. Total 111 posts, group C. The advertise notified in respect of 111 posts. No. All are group C.
But you have separate select list for each of the categories.
This
There
is
was
po-
separate
this-
selection.
these are the postcode, Lordship. Under group C, but these are the postcode.
No, but all these posts have different connotation, different eligibility criteria.
But 14.5% against the 111 posts. Because the notification, because the petitioner also aware in paragraph 8, they have also averred that this notification is followed. And this notification says the 14.5% vacancy in group C. There is no distinction regarding the separate posts. So total 111 posts earmarked for the notified by the oil and gas limited.
Now you are exceeding in one category, you are exceeding, whereas in the other categories, you don't have ex-service.
Only four post code.
How many posts not filled up?
Total, Lordship, now number of candidate provision is selected 16. Candidate undergoing.
Okay, let Mr. Bhattakur come. We'll see.
Right, please. My lord, so-called notice issued, petitioner submitted his reply, cooperated with the hearing, no inquiry report furnished. Now, my lord, on 16/3/2026, a de novo inquiry has been, my lord, directed, that is at Annexure 11, page 58, my lord. And that too by application of power, my lord.
Where is that impugned notification?
Annexure 11, page 58. And that too by application of power. Lordship will kindly come to page 54, Annexure 9. After this honorable court directed for my reinstatement and by revoking the first suspension order, I was reinstated, then second suspension order issued. And while extending that suspension, Lordship will kindly come to page 54, Annexure 9. Very interesting one. No inquiry reports are given, but here there is a mention that it is in my favor. So, my lord, there is a clear violation of Rule 9A of the 1964 rules. May I read?
What is your allegation?
My lord, I was, while serving as the circle officer at Thelamara Revenue Circle, one Lot Mandal was arrested while accepting bribe. That Lot Mandal said that he accepted the bribe on my behalf. That's how, my lord, everything started. A statement of co-accused. I was not the person who was caught red-handed. Lordship, I humbly request your lordship to come to page 54, Annexure 9. May I read two paragraphs, my lord?
What happened to this proceedings?
Which, my lord?
Page 58 proceedings thereafter?
No, thereafter, my lord, I have not been called. They have, on last month, they have issued this, but I have not yet to be called by the new inquiry.
So regarding this.
You say that there is already a inquiry report submitted.
Yes.
And if that be so, how can you have a de novo inquiry?
That's why I'll take instruction, Lordship.
Whether this is a further inquiry,
Look, then-
but you say it's de novo.
De novo what is used? De novo what is
Written
used?
is that hold a de novo inquiry.
But I have to take instruction whether it's a de novo inquiry or a continuation of the earlier proceeding, Lordship. A short date
And
may be
till
written,
the
Lordship.
next day, don't proceed against him. Inform
That's-
your authorities. We are not making any interim direction, don't proceed against him.
Lordship.
Heard Mr. J. Patwari, Learned Counsel for the petitioner. Also heard Mr. S. Dr. Learned Standing Counsel, Revenue and Disaster Management. Mr. Patwari has submitted that in pursuance to an inquiry, submits that with regard to the charges framed against the petitioner, wide show cause notice dated 9/7/2023.
19, my lord.
19/7/2023. Inquiry was conducted by the state inquiry officer. State inquiry officer earlier,
Yes.
state inquiry officer, and an inquiry report has been submitted by him, which was not found to be satisfactory to the respondents, and a further inquiry has been ordered. He submits that wide a notification dated 13/6/2026. The respondent authorities have appointed a new inquiry officer and directed for holding of a de novo inquiry into the charges level against the petitioner. So, Mr. Doctor submits that he would receive instructions as to whether the further the inquiry now directed by the notification dated 13/6/2026 is a further inquiry and or a de novo inquiry. Yes.
Yes, my lord, I am humbly praying because there has to be a stay order. Otherwise, my lord, I have to-
Till the next returnable date, the respondents shall not proceed with the inquiry as ordered by the notification dated 13/6/2026. So, this interim order passed shall be further reviewed on Mr. Doctor completing his instructions in the matter on the next
Short
day.
date maybe.
Raised to list this matter again on 6
Lordship's indulgence, may I make a small prayer, my lord?
5/8, huh?
Look, the alia entry report they have not given to me. I
Five it, we'll see.
They should produce that.
We will see.
Five it.
Five it.
Lordship.
Deeply obliged.
Yes, why does the results are not declared?
Lordship may grant me a short date. I'll provide an update as to what is the stage of recruitment, whether they have started filling up.
Yes, what is the, Mr. Dasgupta, do you have any instruction about it? Heard Mr. A. Dasgupta, Learned Senior Counsel, assisted by Ms. B. Das, Learned Counsel appearing for the petitioners. Also heard Mr. H. Alia, Learned Standing Counsel, Health and
Department.
Family Welfare Department appearing for the respondents. The petitioners in the present petition have projected that they, in pursuance to an advertisement dated
Advertisement dated
Two advertisements.
two address 17/12/21.
pursuant to advertisements dated 17/12/2021.
21
No,
and 10/12.
10/12/21 and 17/12/2021 had appeared in a selection process for recruitment against the post of sweepers. However, the selection process, however, the select list in pursuance to the set selection process against the post of sweeper has not been published till date. Mr. Cholia, Learned, Mr. Cholia, Learned Standing Counsel, Health and Family Welfare Department submits that he would receive instructions as to the status of the selection process initiated by the set two advertisements for the post of a sweeper. For the posts of sweeper. He prays that the matter be taken up on
After 10 days, Lordship. I'll just, at least I'll place the status.
on 7/8/2026. So accordingly, registry to list this matter again on 7/8/2026.
Lordship, can I pray for 10th, the 10th of August?
Mr.
10th of August.
10th he wants,
10th.
7th, 10th.
10th, Lordship.
Your Lordship, in this case, I was dismissed from service on the basis that I'm convicted in the case. But the conviction has been stayed by this honorable court. Your Lordship may kindly peruse page 86. Page 86 for a moment.
But Mr. Dury, under 389, there has to be reasons. Where is the reasons here? Why is the conviction being stayed?
It is not stayed, Lordship, it is suspended. This is suspended, Your Lordship. Yes, suspended, not stayed.
Conviction order, suspended.
Yes, suspended. Yeah, yeah.
Suspended state is the same thing. Now, when was your order of dismissal passed?
It was passed on 2026. At page 111. Sorry, 189.
This factor was not brought to the notice of the authorities. That
The
it was all-
authorities were aware about it, Your Lordship, at page 119, if Your Lordship may kindly say. Second paragraph, may I read, Your Lordship?
Mr. Joyanta Kumar Goswami, J.K. Goswami has signed this order.
Director, Lordship, a different person, Lordship.
But Mr. Dury, beautifully written order.
But Your Lordship.
The basic element he has understood. What he has recorded is that the conduct leading to the conviction,
Yes.
it's not the conviction per se, mandates a severe penalty.
Yes.
So he has understood the proviso to Article 311 and Rule 10C, 10A of our rules. Okay, we'll examine.
Yes, Your Lordship.
Heard Mr. T.S. Deori, Learned Counsel for the petition. Also heard Mr. J.K. Goswami, Learned. You are appearing as
Standing counsel.
Standing Counsel, Animal Husbandry and Veterinary Department. The petitioner in the present writ petition has essayed an order dated 20/06/2026 dismissing him from service in pursuance to his conviction in a criminal proceeding instituted. So, the petitioner submits that against an appeal preferred by the petitioner, submits that in an appeal preferred by the petitioner against his order of conviction and sentencing, this court, wide order dated 13/12/2023 in IA bracketed criminal 1123/2023. What is the criminal appeal number?
426/2023.
Bracket in criminal appeal number, no? Criminal appeal number
426.
426/2023 had kept the order of conviction of the petitioner under suspension till the disposal of the connected appeal. Accordingly, it is the projection of the petitioner that the order conviction being having remained under suspension, the same could not have been reckoned by the respondent authorities for the purpose of issuing the order dated 26, impugned order dated 26/2026. Issue notice returnable 4 weeks. Mr. J.K. Goswami accepts notice on behalf of all the respondents. No formal notice, so and so, so and so, so and so. Registered to list this matter immediately on conclusion 4 weeks from today.
I'm very grateful, Your Lordship.
May I please, Your Lordship? This unfortunate lady before my lord since 2018, Lordship, and she's working since 2002, Lordship. There are several orders for minimums.
You're still working.
Yes, I'm still working, Lordship. Because there is an order of this honorable court not to oust me. "24 years I'm doing duties only."
Now, what happened to the direction of this court at page 73?
There is a speaking order, Lordship. It was passed by Additional District Commissioner, Lordship, Hailakandi. Additional District Commissioner Hailakandi.
Heard Ms. S. Kanungo, Learned Counsel for the petition. Also heard Ms. D. Bora.
D. Bora.
Huh?
D. Bora, Lordship.
D. Bora.
D. Bora.
D. Bora, Learned Standing Counsel, Health and Family Welfare Department, and Mr. Again D. Bora.
Percent government, we have not been served any copy.
Okay, you're not there.
Name-
You're not
name
there.
is
You're
not
not there.
shown.
For the response, Learned so and so. The petitioner in the present writ petition has assailed a speaking order dated 1/7/2026 issued by the Additional District Commissioner bracket Health, Hailakandi, rejecting her claim for being paid a remuneration in the minimum of the scale of pay of a comparable post in the regular cadre. The said order was so passed in pursuance to the directions passed by this court wide order dated 21/1/2026 in contempt case number 424/2023. Oh, so 424/2023. No.
No,
In pursuance to the directions passed by this court wide order dated 23/2/2026 in WPC number 91/2026. Also, issue notice returnable 4 weeks. Ms. Bora, Learned Standing Counsel, Health and Family Welfare Department, accepts notice. This Additional District Commissioner, I think you can accept health. Upara D. Bora, Government Advocate. Accepts notice on behalf of respondent number 1, 2, 3, 5. What about the Hospital Management Society?
That is Hospital Management Society, sir.
Different.
We are not appearing, yes.
5 and 6 registered earlier, maybe.
5. Superintendent, she can appear.
Yes, Superintendent, I can appear.
Uh,
1, 2, 3, and 5, I am appearing.
Mr. D. Bora.
6 and 6, Lordship.
D. Bora, Learned Government Advocate accepts notice on behalf of respondent number 4. No formal notice, huh? Petitioner to take steps for service of notice upon the respondent number 6. A requisite extra copy likhi dibi de. Register to list this matter again after 4 weeks on a date to be fixed by.
Maybe.
Register to list this matter again after 4 weeks, comma, reflecting the name of GA Assam in the cause list.
Deeply obliged.
We may be served, Your Lordship.
Yes, I will definitely.
That Ms. Kanunga will serve you.
Lordship, deeply obliged.
May it please, Your Lordship. My lord, due to certain, my lord, medical issues, my lord, I.
Those periods have been regularized, but you have not been paid your leave salary. Yes, madam.
Lordship, I would like to take instruction on this, Lordship.
Notice.
And what about you're working now?
No, my lord. My application for voluntary retirement was also, my lord, processed.
When did you join your services?
In the year 2000, my lord.
2000.
Today, my lord, as of now, my lord, I have completed 60 years, my lord.
Hmm?
Now, my lord, my age is, my lord, 60 years, my lord.
60 years.
Otherwise also, my lord, I'm in the age of.
You were a regular employee.
Lordship, my lord.
Yes, why his salaries are not being disbursed, madam?
Lordship, Principal Secretary, respondent number 6 has written to the Joint Secretary Hills Area
For
Department.
the release of the money, 10
Lordship.
lakh or something.
Lordship, my lord.
Okay, receive your instructions.
Lord.
But is there any point? Anyway, you will have a adjournment prayer again. So give me a date of, as per your convenience. If it doesn't come, 2 o'clock, the officer will be here from Kirby Angle. You give me a date as per you. A man is waiting for such long time, will not. Yes, when?
After a week, Lordship.
You give me a date, madam. Miss so-and-so, heard Mr. K. Borua, learned counsel for the petitioner. Miss so-and-so, learned standing counsel, KAC, submits that she be granted time till,
Should 7th of August.
time till 12/8/2026 to complete her instructions in the matter and apprise this court as to why the salary, relief salary of the petitioner is not being released, and further as to why his application for proceeding on voluntary retirement has not been given a consideration. Registry to list this matter again on 12/8/2026.
Lordship.
Yes, some typographical error. I may be allowed to withdraw this petition with a liberty to file a fresh.
Mr. M.K. Sharma, learned counsel for the petitioner, submits that certain typographical errors, inadvertent typographical errors have occasion in the present petition, and accordingly prays that he be permitted to withdraw the present petition with liberty to refile the same. Also, prayer accepted. The present petition stands dismissed on withdrawal with liberty as prayed for.
Alia.
Please, Lordship. Lordship, Argo Council on Lake on court number 4, Lordship. Kindly after some time, Lordship.
Yes, Ms. Sharma, what is this happening? He seems to have got the cutoff marks
Gotcha.
above his claim. Now, why was he not appointed? Admittedly, the cutoff mark is around 64. He says that he got around 60. Mr. Muzumdar, 67 you got. You got 67.
Lordship,
Any material to disclose that?
Lordship, it is at page 52.
52. That is the cutoff marks. Where is your marks?
Oh, yeah, Lordship.
Other than this statement, is there anything? In your representation at page 58, you have made a mention. Heard Mr. A.L.R. Mojumdar. You get your instructions.
Lordship.
L.R. Mojumdar, learned counsel for the petitioner. Still militancy affected Naxal district is considered in the state of Assam. We don't have any district which is now declared as militancy affected. Everything has been withdrawn. We don't have a Naxal district also. So this selection, you seem you are still following that. Reckon it?
Lordship pays 44 kindly, annexure 3.
74.616. Huh? Samit heard so and so and B. Sharma, learned CGC appearing for the respondents. The petitioner submits that he had participated in the recruitment exercise undertaken for recruitment against post of constable bracketed GD in Central Armed Police Forces and SSF, comma, rifleman bracket GD in Assam Rifles and Sepoy in Narcotics Control Bureau examination dash 2025 and had secured therein 74.61697 marks. It is projected that the petitioner belongs to the economically backward section bracketed EWS. The petitioner further projects that the cutoff marks for DSF for the state of Assam in relation to Naxal/militant affected districts was 64.06784. So, accordingly, the petitioner submits that although he had secured marks more than the cutoff marks, his name was not included in the select list so published, and being aggrieved, the has instituted the present petition. Ms. B. Sharma submits that she be granted 2 weeks' time to complete her instructions in the matter. So, I accepted a registrate to list this matter again on 12/8/2026, on which date Ms. Sharma shall apprise this court as to why the petitioner has not been favored with an order of appointment.
All right.
Extra copy.
Limited prayer, man, that the representation that has pending, that may be disposed of at this.
You're a whistleblower.
My lord.
This is nothing to do with your service.
No, no, no.
How come
no,
this
no,
matter
only
is
thing
listed
is that
before this
because
court?
all of the employees of that treasury were blamed. That's why, my lord, that
No, I
inquiry
got
was
it.
conducted, that is
I got
pending.
it. I got it. What is this post? Senior accountant?
That is I am
Not a
the senior
it's not a
accountant,
gazetted
that is the
post.
chief treasury officer,
Chief Treasury Accountant.
chief treasury accountant.
What is the next promotion?
Next promotion, my lord, that's senior treasury accountant, chief treasury officer.
This is a district level post, Lordship. I mean,
Next promotion is what?
I think going by the treasury rules, Lordship, probably he has no other option. That is the
Final post.
final position, Lordship. It's a senior post, Lord.
Mr. Naik, have you
Conclude.
see what?
Yes, I understand, Lordship. He has a grievance against his senior,
But
Lordship.
whether this would be maintainable?
That is the first question, Lordship. Now, what is his grievance basically, Lordship? It is a
He has
complaint.
got no service grievance.
Yeah.
Means
See,
magistrate.
this is
only a
the
complaint.
best of bench four matter.
Yes.
Or a bench four matter maximum.
Only thing, my lord, that since magistrate inquiry has conducted, man, that may conclude. Right?
But Mr. C. Goswami, learned counsel for the petitioner. But Mr. P. Naik, learned additional advocates general appearing for the respondents. Mr. Naik submits that the matter be taken up on 10/8/2026, on which date he shall complete his instructions in the matter. Also, as projected by the, as submitted by Mr. Naik, comma, the maintainability of the present petition is kept open. Also, registered to list this matter again on 10/8/2026. I am having my serious doubts with whether this would be maintainable, and if maintainable, whether before dispatch. Because this does not come within the definition.
It's for or
You also examine these issues. Right.
Yes, Lord.
Heard Mr. M. Islam, learned counsel for the petitioner. Also heard Mr. A.K. Ghosh, learned standing counsel, learned standing counsel, health, Panchayat and Rural Development Department, and Ms. D. Das Borman, a learned additional senior government advocate. Full stop. Issue notice returnable 4 weeks. Mr. Miss D. Das Borman to accord debate. Ms. D. Das Borman, accepts notice on behalf of respondent number 1, 2, and 5, while Mr. A.K. Ghosh, learned standing counsel, Panchayat and Rural Development, accepts a notice on behalf of respondents number 3, 4, 6.
3 would be finance.
4,
4 and 6.
4 and 6.
It would be 1 also, Lordship.
And Ms. N. Hajarika, learned counsel appearing for Mr. P. Nayak, learned standing counsel, Finance Department, accepts notice on behalf of respondent number 3 and 7. No formal, as all the respondents are represented, no formal notice. The registry to list this matter again after 4 weeks.
Lord, one maybe my lord, Mr. Ghosh, my lord. One PNID, my lord.
Well, Lordship, it has been wrongly written as Chief Secretary, but it will be additional Chief Secretary, PNID.
PNID.
Or additional chief secretary. Okay, according to me, goes of dividend number 4, 1, post 1,
1, 4, 6.
1, 4, and 6. D. Das Borman 2 and 5.
Really obliged, Lord.
Obliged, Lordship.
May I please, Lordship?
Yes.
Lordship, the petitioner is a community health center, health officer, Lordship. He is working as Karbi Anglong, Assam, Lordship. But he belongs to Rajasthan.
Now, Mr. Counsel, the recruitment was an all India recruitment. Advertisement for all the posts of that post was advertised for all over India. And he was recruited, then he was posted to NHM. Have you seen?
Yes.
Was that the position?
Advertisement, Lordship.
See, advertisement that was issued,
Yes.
was it issued for all India posts? Say in all the states of Assam, how much of our post of, what is this post? Community health officer was
Yes,
advertised. And on selection, he was posted to Assam. Is that the position?
Yes, Lordship.
Or it was an advertisement issued by NHM Assam?
Advertisement, Lordship, although I have not gone through this advertisement right now. Lordship.
Forget,
But
you have
yes,
not
Lordship,
brought it.
yes.
Then
Lordship,
what
it
is
was-
your, how do you claim this transfer? What is the basis?
Yes, Lord, basis, Lordship. Now,
How
although
can the
Lordship-
authorities of Assam
Yes.
transfer you to Rajasthan?
Lordship, that Lordship, that may be problem for the Assam mission director.
Huh?
That
Mission
may-
director
yes.
has jurisdiction in
Yes,
Rajasthan
Lordship,
also.
that may be problem, Lordship. That's all, Lordship.
Then
The
problem
Honorable
means
High Court, Lordship, directed to dispose of the representation, Lordship, by the Secretary of the.
forget the disposal, forget the thing. You show me the right of the NHM authorities in Assam to transfer you to Rajasthan.
Rajasthan, Lordship, this issue, Lordship, that's why I'm saying, Lordship, this issue may feel the difficulty by the Assam authority, Lordship. That's all, Lordship, this issue, Lordship, was supposed to answered by the national level, Lordship.
So show me that your recruitment
That's all,
condition.
Lordship, High Court, Lordship.
Mr. Counsel, show me that your recruitment was for an all India post.
No, Lordship, that.
You are not
Lordship,
recruited for all India. You were recruited against a process which was initiated by NHM Assam. Similarly, process in NHM Rajasthan. Similarly, in West Bengal. There are all independent bodies, societies, state
Yes,
level
Lordship.
societies. They don't have this. You do one thing, you resign here, go and try for a job in Rajasthan. That's the only way out.
If this, I have to take another job, there should be difficulty, Lordship.
Then
otherwise, Lordship,
we
if
find
Lordship-
we find that your claim is not maintainable. We find no error in the speaking order.
So, Lordship, speaking of is error in the sense, Lordship, Honorable High Court, Lordship, that's why Honorable High Court was directed to dispose of this representation by the Secretary of the Central Government, Lordship. Lordship, may kindly see
You
that.
file a contempt that has not been done, but we are
Lordship,
not.
that was not done, Lordship. That answer is given by the Mission Director, Lordship.
Huh?
The answer is going to the mission director.
This
So,
is
Lordship,
fine.
which part is left?
If the order of this court is not complied with, in the manner directed, you file a contempt.
No, no, central government, there is the Lordship, but somehow they have done something, Lordship. That's why I filed writ petition, Lordship, till the disposal of this representation by the, answered by the.
No, sorry.
No, Lordship.
This is not an executing court. You file a contempt against this, we understand. Let them answer, but we will not permit you to.
In the meantime, Lordship, someone has given answer, Lordship. Now this.
We find that this answer to be correct. Even the central
As per
government
the
cannot.
mission director, it may correct. As per the mission director, it may correct. But Lordship, the mission director was directed to give the answer, Lordship.
Okay, where is
Answer
your
given-
representation?
Representative, Lordship, page 38, Lordship.
You file a contempt petition against all these persons, excluding NHM Assam. The contempt petition the court will see.
Sure, I can also do that, Lordship. But in the meantime, Lordship, now, as per the speaking order, Lordship, again, mission director may take appropriate action, Lordship, disciplinary action against me, Lordship.
He will have
Yes.
to.
Then,
He will
Lordship,
have
it
to.
will be another debate for Lordship, page 46, Lordship.
We can't help it, Mr.
Lordship, then Lordship, somehow, something, Lordship, can
Nothing
protect
can
me, at least disciplinary proceeding, maybe, Lordship, state,
We will
Lordship,
not
then,
permit
Lordship, I
this.
can, in
We
the meantime,
cannot
Lordship, I can
permit
also do
this.
that, Lordship.
We cannot permit this.
Otherwise, Lordship, if they remove me from disciplinary proceeding.
Who is appearing
independent
for the
Lordship, then,
central
Lordship,
government? Yes.
My
You
contempt-
undertook. What happened? Have you disposed? Why have you not disposed of the representation?
Should have been disposed, my
Then-
lord, but not from
Get
this,
your instruction.
I'll get answer,
Mr. I. Botaku, CGC,
my lord.
submits that he be granted 2 weeks' time to receive his instructions in the matter. Whoso, pray accepted, registry to list this matter again on ten eight 2026.
Obliged. 10-8.
So timing kita. Begin. But Mr. M. Sekia, Learned Counsel for the petitioner. There is no representation on behalf of the respondents. Who is the authority who was to give the instruction?
My lord, CDPO, Hujai,
CDPO? Lonka,
Lanka.
Lonka ICDS project. Mr. Get your Lonka man here. Why is he not furnishing instructions at 3 o'clock? Because nobody seems to be interested.
That's good.
Huh? Lekha. Halka rakha. The matter was adjourned on Pusa. None appears for the respondents. The matter was taken up for consideration on 17/6/2026. And Mr. P. Saikya, Learned Government Advocate, was required to take the necessary instructions in the matter. And for the said purpose, extra copies of the writ petition was filed to the said respondent. Today, when the matter was taken up in its turn, a prayer for adjournment, a prayer for taking up the matter of after some time was so made on behalf of Mr. P. Soikia. The matter was again taken up.
I know.
However, there is again no representation.
May I please, Lordship, in this case, Lordship, P. Saika, he is out of station, Lordship.
We don't know.
No, he has gone to the, for plant
Fine,
relief.
but he has gone somewhere.
Tomorrow,
It's a very noble thing. But what about the instructions?
But not till I will take instruction, no, from tomorrow, on tomorrow, Lordship.
Huh?
Leave the matter on tomorrow, Lordship. I will take instruction, Lordship.
This is not done, madam.
Yes, Lordship.
We understand Mr. Saikia. Mr.
Yes.
Saikia is just one of the many government advocates.
Yes, Lordship.
So why has this respondent been noted that this is a matter pending, this is the instructions required?
Yes, yes, Lordship. Tomorrow, Lordship, I.
What idiot? On the prayer of Ms. D. Das Burman, a registry to list this matter again on 31/7/2026. On the next date of listing, if the instructions, requisite instructions are not furnished to the learned government, additional senior government advocate by the respondents, comma, necessary orders as would be mandated would be passed by this court in the matter, including the requirement, passed in the matter. Full stop.
Obliged.
My lord, I have the instruction to withdraw this petition.
Ms. Mr. AHMR Chaudhary, Learned Counsel for the petitioner on instructions has submitted that the petitioner desires not to press the present petition any further, and accordingly he prays that he be permitted to withdraw the present petition. Prayer is not objected to by Mr. C.K.S. Borua, Learned Government Advocate, appearing for the respondents. Also, in view of the above submissions of the Learned Counsel for the petitioner, the present petition stands dismissed on withdrawal.
Obliged.
Yes.
He still is in court 10.
Huh?
He still is in court 10. His matter is going on.
Second up. Second up.
Lordship, there has been a change in the CTPO in the item number 12, my lord, and 13 have just informed that he is under process, my lord. We'll receive the in a day or
But
two.
why this laxative attitude that we have given you instruction, they'll process in their own? What is this?
Lordship, there has been some miscommunication and they have been trying
That
to
is being
figure out.
really happening in your PTC. Why?
Lordship, I'm
Don't have
sorry
a
for
system
the-
in place.
Lordship, I pray for a week's time, my lord.
No week's time. Who
Lordship,
is the CDPO? Why is he so busy that he can't respond to the court's requirement?
Lordship, he is saying that it will be received in a day or two, my lord.
Day or two.
Lordship.
The prayer of Ms. B. Borua, Learned Standing Counsel PTC.
Friday.
Further time till Friday date today is granted to complete instructions in the matter. No further adjournment shall be granted for the purpose.
Lordship, in item number 13, my lord, applied for Anganwadi worker, my lord.
No, I have not said anything.
Obliged.
Obliged.
A2 case couldn't that issue. When I post the other matter? Monday. To time Monday did ya? 3-8 together. 3-8. Item?
14.
Yes, Mr.
Lordship, how can it be, your lordship, in one category, your lordship? It cannot be. Qualifications are different.
But lordship, the private responses are not made as party response, lordship, already.
That you take in your.
Lordship, then lordship may have the matter on Wednesday, lordship.
I'm not passing any interim order. I'm issuing a notice. You file your affidavit, then we will see. Because it seems that 4 times, this is the 4th time Mr. Bhattakur is here.
Yes, lordship.
We will stop him from coming back here. He can go up on appeal. Heard Mr. S. Bhattakur, Learned Counsel for the petitioner. Assisted by Mr. D. Ugli, Learned Counsel, Senior Counsel, assisted by Mr. D. Ugli, Learned Counsel for the respondents. For the petitioners. Also heard Mr. K. Kolita. You are the only respondent.
Yes, lordship.
K. Kolita,
1, 2, and 2.
Counsel appearing for the respondents. Issue notice returnable. (26/8/2026). Mr. Kolita accepts notice on behalf of all the respondents. No formal notice is to be, as all the respondents are represented, no formal notice is to be issued. However, requisite extra copies of the petition be furnished to the Learned Counsel for the respondents. Also, as it is projected by the Learned Counsel for the respondents that the posts advertised have already been filled up.
Some of the candidates joined, lordship.
Huh?
Some of the candidates joined. Lordship, I have.
All have not joined.
Not.
Registry to list the On or before the next date of listing, the respondent shall file their affidavit in the matter. Also, registry to list this matter again after Kundina issue date 26.
Lordship, in para 15, I have made a categorical affirmation.
They are working. Let's
No,
not
no, that is not the case. That they have not disclosed the list, Your Lordship.
Fine.
If I got the list, I can make them.
Okay, fine. Let them take that plea in the affidavit. He, if on one hand says filled up, he says, further says there are posts vacant. We will see.
No, Lordship. I have placed the instruction, Lordship. Out of the 16 ESF, 7 have joined, Lordship. Ex-servicemen 7 joined, Lordship. I have already placed the instruction.
File your affidavit. Explain. Para 14, 15, all those statements, then we will see. And again, my doubt, how can you concentrate that in one post and not distribute in the all? 14.5, 6 point be given. One excess, okay, we understand. But it cannot be 14. That means you are eating into the quota of the petitioners. We'll see. We'll explain. You explain.
Deeply obliged.
You may have a very filtered explanation by oil filter and all.
Obliged.
Please, Lordship. Lordship, we have received the affidavit, Lordship, filed by the respondent, Lordship. For some clarification, Lordship, we need to file affidavit from our side, Lordship. The petitioner couldn't come, Lordship, due to the flood, Lordship.
Oh.
At least 10 days may be given, Lordship.
It is submitted by the learned counsel for the petitioner that an affidavit on behalf of the respondents have been filed on 17/7/2026. Accordingly, it is prayed that the petitioners be granted time till
At least 10 days, Lordship.
14/8/2026 to file a rejoinder to the affidavit filed by the respondents. Registry to list this matter again on 28/2026 for further hearing.
Highly obliged.
Please, your Lordship. Then may kindly be passed over for the day as the learned counsel could not appear today due to some personal. Learned counsel could not appear today due to some personal difficulty.
So what should we do?
It may kindly pass over the matter.
You have also not filed an affidavit here.
Lordship, I have not received any instruction, therefore I could not file any affidavit.
Ms. P. R. Devi Learned CGC submits that she be granted further time till 14/8/2026 to file an affidavit in the matter. Also, it is to be noted that several adjournments have already been granted. Submits that adjournments earlier has been granted for to facilitate filing of affidavits by the respondents. However, no affidavit has been filed. The matter is pending since 2022 in the records of this court. Accordingly, a last chance is granted to Ms. R. Devi to file an affidavit in the matter. Registry to list this matter again on on 14/8/2026.
This matter relates to absorption of additional mandal to the post of mandal, Lordship. During the pendency of this repetition, Lordship, and the interim order, there is interim order, they have issued this advertisement for filling up this post, Lordship. And in another repetition, I have challenged the advertisement. WBC number 3661, 2026.
R. Devi submits that the present writ petition be taken up along with WPC number
3661.
3661
26.
2026. Prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter. When is it listed? Under what?
Lordship, it was listed on 17/7/2026. Lordship, wrongly listed in bench 2.
Ah.
It was directed to be listed last week. Lordship, it was not listed.
Along with so and so on a date to be fixed by the registry.
6 Lordship, 6 August.
It'll come.
Obliged.
Yes, anything further hearing to be required? No.
No, my lord.
You want to hear this matter? Says make some submissions.
No, my lord.
No. You also have.
AIGC doesn't have the
Government also not have. Third day, learned counsel for the party such length. Hearing concluded, registry to list this matter again. Last of all, for delivery of orders. 25/8.
Right. Obliged.
May I beg your lordship? Kindly peruse the last order.
Lordship, affidavit has been signed today, Lordship. Affidavit has been signed today. The officer was out of station, Lordship. So
Ms. R. Devi
by tomorrow,
submits that
we will
the
file.
affidavit on behalf of the respondents represented by her would be invariably filed on or before 24/7/2026. Registry to list this matter again on 10/8/2026.
That's it. Obliged.
None appears for the petition on call. Mr. K.K. Parasa, learned standing counsel, learned
Yes,
CGC is present for the respondents. For the ends of justice, registry to list this matter again after 4 weeks on a date to be fixed by.
Obliged.
But in this case also, they are yet to file their affidavit, lordship.
23 matter, we give you that advantage. Yes, what is your grievance?
Yes. Petitioner was initially appointed as a master.
You are a personal post holder.
Yes,
How can you be promoted? Dilip Talukdar.
yes, that is.
So
the-
that will go.
In fact, what has happened, lordship, we submitted various representation to
Fine,
the.
I got it. But when
authorities.
there is a decision of this court
Yes.
in Dilip Talukdar, upheld in the division bench, what more, how can we direct for your promotion?
In
Like
fact,
from a personal post.
in fact, while during our service career, we have submitted various representation.
Mr.
Or-
Ganguly,
Lordship, I
the
understand. lordship,
issue
that
is
difficulty.
whether you are covered by Dilip Talukdar.
Lordship.
If you are covered by Dilip Talukdar, a mandamus cannot be issued.
Only
So
difficulty
that is the end of the matter.
I've been working since 1988.
I can't help it. Go and
Lordship, I
file a
understand.
review with that division.
understand.
Can't help it. Can't help it. So we close it.
He is retiring in the month of January 2026.
You show me a way out.
I understand, lordship.
I will pass orders in your favor. That's it. Anything more is required? Then I'm getting dismissed.
As far as item number 29,
Ah.
lordship, this matter, it is shown that he was serving, his services was regularized to a sanction post, lordship. As
Where?
item number
29 or 30?
30.
30. Gojendra.
That, and page 21, annexure 5.
21 annexure 5.
May I read, lordship, for a moment?
Just a.
In fact, he had earlier filed a repetition before this court, and this court
Where is your order of regularization?
that lordship will, page 18 and 20 is the order of this court. May I read this order, lordship? Petitioner was initially appointed as work charge Khalasi cum Chokidar of the Executive Engineer Public Health Engineering Department, Bangla on 28/10/86. By office order number 33 dated 28/10/1986.
Ganguly, learned counsel for the petitioner. Also heard Mr. I. Borthakur, learned standing counsel, PHE department. Also, Mr. Borthakur submits that he be granted time till 14/8/2026, 21/8/2026 to file a rejoinder, to file an affidavit on behalf of the respondents respondents represented by him. It is seen that several adjournments have been taken by the respondents in the
He is
PHE
retiring
department.
in October, Lordship.
Huh?
This person is retiring in the month of October, Lordship.
Had taken several adjournments for filing of an affidavit. However, no affidavit has been filed in the matter till date. So accordingly, registry 21 December itu continue. Accordingly, as a last chance, the respondents in the PHC department is granted time till 14/8/2026 to file an affidavit in the matter. Registry to list this matter again on 21/8/2026. In the event the said affidavit is not filed, this court would proceed to consider the issues arising in the present petition basing on the materials already brought. We are dismissing this, keeping this alone. It will dismiss that.
God bless.
Second about Tidlio Mount Abasco.
Maybe Lord, my lord. Similar issues are appeal is pending, my lord.
Similar issue means what?
I mean, regarding the appointment of the Jolomitra, my lord.
Jolomitra would come. What is your case?
My lord, I also this challenge the private respondent, he was the appointed.
Private
Jolomitra.
respondent. You say that you are the landowner,
Yes, my lord.
right?
Yes, my lord.
So land donation was made when?
My lord. My affidavit, my lord, I stated that part, my lord. My lord, my submission, the similar issue, my lord, regarding the.
Forget the similar issue. You tell me your issue first. You are a landowner.
Yes, my lord.
Land donation 40, 45, 40, 50 years ago. Your brother worked. Your uncle worked.
No, my lord. My father worked.
Your father worked.
Yes, my
Okay.
lord. Kindly my
Then-
additional
then-
affidavit, my lord.
Then
That's
Mr. Counsel, this court takes time to understand. That is
Yes, my
fine.
lord.
You are very fast. This court is old chip. Now tell me one thing. Where is the document envisaging that the donation was made?
My lord, kindly, the land holding certificate, my additional affidavit.
Forget the land holding certificate. I want the gifting.
That where is mentioned, my lord, my land was donated, my lord.
Where is it mentioned?
My lord, I am going through, my lord. My lord, in page 75, in affidavit in opposition, annex B, my lord. The circle officer issued, and my lord.
This land is in your name.
No, my lord. My father name, my lord.
Father's name. Okay.
Yes.
Now, where is that land donation you made?
My lord, my lord, they used my land, I file a title shoot, my father file a title shoot.
Okay, fine. We'll come to this title suit. But where is the land donation?
Actually, my lord, I have not studied today, my lord. That is.
Now, Mr. Ali, you say that you have donated the land, right?
Yes, my lord.
Is that your stand?
Yes, my lord.
Then why did you file this title suit? For declaration of right title interest, therein there is no whisper that you have donated this land. So your stand is contradictory. You say that the government had forcefully taken over this land from you in your title suit. And that on that count itself, we are dismissing your writ petition. On the prayer of Mr. H. Ali, learned counsel for the petitioner. Mr. H. Ali submits that he be granted further 2 weeks' time to further prepare the matter and make his submissions. Prayer accepted. Registry to list this matter again. 4 weeks' time. 4 weeks' time. After 4 weeks, on a day 2 weeks. Give me this basic facts, then we will see. Yes, where is the? Where?
We have filed the affidavit today, my lord.
No, affidavit you filed. What is the profit and loss?
So we'll see.
₹13 crores and still not paying. Huh?
But my lord, expenditure.
Huh? Mr. A. Jahid, learned counsel for the petition, submits that in response to the queries, in response to the requirements made by this court by the order dated 17/6/2026, an affidavit is being filed in the matter today by the additional affidavit is being filed in the matter today by the respondent number 2 and 3. He submits that the same, that the present petition be taken up along with the said additional affidavit. In view of the above submission of Mr. A. Jahid, registry to list this matter again on 6/8/2026 along with the said additional affidavit being filed today by the respondents number 2 and 3. You go through that and tell me.
Obliged.
Mr. Jain, you take this.
Actually, Gauhati case, my lord. So, when this
Yes.
yes, my lord. Already appointed in the year 91. Subsequently, their affidavit shows that.
There is a similar matter pending in the writ appellate court. That's what was told me. We'll give it 2 weeks time so that that matter can also be, as agreed to by the learned counsel for the parties, registry to list this matter again on 14/8/2026.
All right.
Wait, please, your lordship.
Yes.
In this case, your lordship, the dependency of the case, your lordship, it is not to have expired. I have filed a substitute petition, but it is not on record. Next.
Mr. Learned counsel submits that during the pendency of the present petition, the petitioner number 2 has passed on, on
15/12/2025.
15/12/2025, and he has already filed an interlocutory application for substituting the petitioner number 2 with his heirs. He submits that the said the present writ petition be taken up along with the said interlocutory application. Prayer accepted, a registry to list this writ petition along with the interlocutory application stated to have been filed by the petitioner, on 14/8/2026.
Short date, next.
Huh?
Next, short date.
Short date, 7/8/2026.
Obliged.
And madam,
They have not.
how was he appointed? How were they appointed?
Lordship, that's what I have received the instruction, lordship.
Huh?
Personal post, it's a personal post, lordship.
And Mr. Islam, You were appointed against two persons who were regularized against personal posts. How could you have been appointed in the first place? Because those posts were not there. The post will lapse on the death, retirement, or any other eventuality. So that post could not have been continued with. We'll say you file. We'll say.
Let them file everything. They are not
You
like
file
that.
an affidavit.
Obliged.
But is he working till now?
No, no, Lordship, after we have found
September
out,
19.
yes, after that, he has not been engaged. He was not working after
You
that.
make that categorical statement in your.
Lordship, Lordship. Obliged.
Miss R. Doctor, appearing on behalf of Mr. S.K. Medi, is present for respondent number 3.
Lordship, we have filed affidavit that was not on record. Filed on 24th.
Affidavit, I'll require some time to put in a short rejoinder mail. Last time it was,
It is submitted by Mr. S. Sutroda,
Yeah.
counsel appearing for the
Respondent 3 and 4.
number
3 and 4.
respondent number 3 and 4, that an affidavit on behalf of the said respondents have already been filed. Mr. K. Talukdar, learned counsel for the petitioner, submits that he be granted how much?
a week's time.
10 days time to file a rejoinder to the said affidavit. So accordingly, registry to list this matter again. (11/8/2026).
Because in the meantime, even if the union could file an affidavit, because
That is
they
up
are
to
the
them, if they want.
many direct. I'm good.
Madam, they are following CCS. Yours 2020 does not make any differentiation. Now the 23 one, you say will only apply to government servants, will not apply to autonomous institutions. It's not the question how whether it is an autonomous institution, government, it's not that. It's whether that institution had adopted CCS pension rules. If it is adopted CCS pension rules, why will not the amendments, introductions, reductions to that rule be applicable to them?
That will be all over India, same rule.
No, see, all autonomous institutions do not have a pension scheme, right? They may have a CPF scheme. But if an institution per se, you have IIT has a CCS.
Yes.
If the IIT has adopted CCS pension rule, this will automatically flow. And file an affidavit. Because you have said that this will not apply to autonomous institutions. I understand.
But is that till that no instruction is issued
Uh,
from their end?
You pursue. The autonomous institutions cannot be generalized because there are autonomous institutions which have adopted CCS pension rules and they are paying. And there are institutions wherein CCS pension rules have not been adopted. So whether they are recruited prior or post does not make any difference. Just make that
Lordship,
distinction.
in that case, Lordship, a line that may file an affidavit and it's little time.
It is submitted that the issue involved, considering the issue involved herein, the respondent number 1 is directed to file an affidavit on or before the next date of listing. All of piece idea. 4 weeks ko idea. 28 na? On 28/8/2026. We'll get them also to file an affidavit.
Hearing the lawsuit, the petitioner is the son of.
What is your name, Dhruvo?
Dhruva Kumar Das.
But
But
they
in
say
the
that
record, it has been recorded as
Dhruvo
Dhruva
Jyoti.
Yes, we have already, there is an affidavit, we are going to bring on record, your lordship. The same person in other documents, your lordship.
Yes, Mr. Bora, what is your instruction?
Your Lordship, we have actually drafted an affidavit and sent it for vetting way back in June, but so far you have not yet.
So what is your stand?
Otherwise, I only appear for respond numbers 2, 3, 5, 6, 6, and 7. With regards to
This has
respond
got
of
nothing to do with the Union of India.
no,
Union of India has already given an appointment to the younger brother.
yes,
Now, in spite of that, you have a scheme that in spite of that appointment, he is still entitled. But the death here of the martyrdom occurred prior to 23. So how do you reconcile this?
so your lordship, this is of course not reflected in the affidavit.
Then why are you filing an affidavit?
We are just attaching the inquiry report which we are directed to conduct an inquiry. So the district commissioner, your lordship, so
No,
the SP.
I want the affidavit from the competent authority of the government.
Your lordship, because we have been directed to conduct an inquiry and we conducted an inquiry and so we were just. through this affidavit,
GAD.
We are only bringing that inquiry report on
No,
record.
who is for appearing for GAD?
GAD, their name is not reflected in.
Is there a party respondent? GAD?
They are a party
Yes, yes.
respondent.
Huh?
They are party respondent.
Okay, registered to list this matter again. After a week, reflecting the name of the standing council, GAD. Where is GAD?
Respond number 1 and 8. Lordship, Directorate of Scenic Welfare, GAD, actually.
Okay,
They are
that is the respond number 1.
1 and 8. Yes.
8 also.
8. Directorate of Scenic Welfare.
It's under GAD.
GAD.
1 and 8.
So they are the main party. Actually.
That's it. Mr. Majumdar, we'll have to get the instruction from the presidency.
Last opinion, my lord, it's possible that whether I have completed 17 years of service or not, the high school.
Huh?
In high school, my lord, I have completed 17 years yes, whether I have or not.
No, where is your order
Yes.
posting you to HDP?
Yes, my, that is at the page, my lord. Page 24. 24, some my lord, a typographical error is there.
No, show me the original.
My lord, page
How
20
do I
page
draw a
25.
conclusion?
Page 25.
20?
5.
Huh.
Cross 2, my lord.
Hmm.
In the interest of public service, Sri H. Sharma, Assistant Teacher, Upper Desari, and
Mr. M.K. Sharma, learned. Can you file a better copy? Did you work there?
yes, ma'am.
Huh?
This is more better than this.
No. Did you work in HDP?
Yes, madam. More than 5 years, madam. More than 5 years.
Okay. Nothing more. We can dispose it of.
My senior wanted to appear in the matter. Can it be fixed at 2?
We are disposing it of. We'll give you a liberty. You examine whether he has served for 17 years in a high school, because now it's high school 17 years would do, or an amalgamation of high school and higher secondary school. He has experience in Bokajan. And now whether this HDP also is there, examine. If it is there, give him an opportunity to appear. That's all.
Thanks. All right.
2 o'clock.
Fine.
Your lordship, in this case, I have a cell, the order of dismissal, your lordships. It is page 78.
What is the error in the order of dismissal?
Your lordships, at the time of passing of this order, your lordships.
Where is that order?
Order is page 78, your lordships.
78.
Your lordship.
As on 16/12/25, when this order was passed, what is the error?
Your lordships, right way, I was, your lordship, dismissed from the services, your lordship.
Actually.
And my conviction is under 498A. So your
Show me a law that 498A will not tantamount to dismissal.
subsequently, your lordship, subsequently, my conviction was the state.
I'm not on that. I am on 16/12/2025.
But your
On
lordship-
that day, there is no error because
but
your
your
conviction
lordship,
was holding
order
the.
dated- Order dated 21/5/2026 may be there is one also. There is a direction to the state, your lordship, for reconsiderations.
Yes, any decision taken.
No decision was taken on that day, lordship. Lordship had rightly indicated on 16/12/2025, lordship. There was no any suspensions regarding. Otherwise, lordship, he has filed an additional affidavit, lordship, to bring on record the order. My lord, may kindly press page 85, lordship. Page 85, lordship. And last page is, lordship, 87, lordship, paragraph 13, lordship. On the basis of that, he can prefer an appeal under Rule 29.
That is
lordship.
what I am trying to
Rule
say.
29 of SSB.
Say, Mr.
Lordship.
Jha, this order would have a prospective effect. That
Lordship.
means from 24 to 2026. You were already dismissed on 16/12/2025.
Your lordship.
This order was never, even when you filed your writ petition, this order was not there.
Not there, lordship.
Not there, your
Not there.
lordship.
So do one thing, we will provide that you file a fresh appeal
Lordship, under
before the respondent
Your
authorities.
lordships, regarding appeal, your lordships, please, order may be perused, your lordship, again.
Which appeal? Which order?
The order of dismissal, your lordship.
Hmm.
Page 79.
Hmm.
I was dismissed by the central government.
Huh?
Central government.
Huh?
Then your lordship,
I'm not asking you, I'm asking you to go back to the authority
Lordship,
who has passed this order, Director General, saying that these are the subsequent developments. These have not been, because the very basis of your dismissal is now gone.
Lordship.
But again, prospectively, go back to them, file an appeal, file a representation. I will direct them to consider that.
Lordship, lordship, lordship. That will easier for him, lordship. Otherwise, lordship, it will be.
Because see, on the date when this order was passed, this
Conviction
order
was-
was legal order. Subsequently, after around
but,
maybe
but
2 months,
your lordships, also on the date of even passing of that order, your lordships, it is not about a moral turpitude, your lordship. It is in between, even his affidavit they file, your lordship, he is admitting that.
okay, then we will only decide on 16/12, whether that is valid or not valid. Make your submissions.
Rule 29 तक अपना सुविधा हुए सब में क्यों नहीं देना?
Mister, you have been convicted. You are 3 years. The conviction was not stayed.
No,
It was
stayed.
only the sentence that was stayed. What is the error in this?
Same sentence was stayed.
Then what is the error?
नहीं अपील जाओ.
You file a representation, you look into it. Okay, do whatever you want.
Your lordship, I will file a please.
You withdraw this, we'll give you liberty. Okay, we'll cut Mr. So-and-so, learned counsel. You want to think over the matter further?
Your lordships, one date may be given, your lordship.
You give me a decision that this is permissible.
Your lordships, observation may be made, your lordship, I will go to the.
Better अपनी appeal file करो 29 तो अपने काम होगा.
Heard Mr. So-and-so, learned counsel for the petitioner. Also heard Mr. K. Gogoi, learned CGC appearing for the response. The present writ petition was instituted by the petitioner, assailing an order dated 16/12/2025, passed by the competent authority, imposing the penalty of dismissal from service upon the petitioner in pursuance to his conviction by the Court of the Learned Subdivisional Judicial Magistrate, Bhagalpur, Bihar. Also, the petitioner, on being convicted by the trial court, void a judgment and order dated 26/8/2025 under section 498A IPC, was sentenced to undergo 3 years rigorous imprisonment along with fine of rupees 3,000. The petitioner, being aggrieved by his conviction, had assailed the same by way of filing a criminal appeal, being criminal appeal number 35/2025 before the Court of the Learned Principal Sessions Judge, Bhagalpur. The appellate court, void order dated 23/9/2025, had suspended the sentencing of the petitioner till the disposal of the appeal. Accordingly, the competent authority of the respondent of the department, on consideration of the said aspects of the matter, and also noticing that it was only the sentencing that was suspended and the conviction continued to remain effective, proceeded by the order dated 16/12/2025 to dismiss the petitioner from his services. During the pendency of the present petition, the petitioner has filed an additional affidavit and therein has brought on record an order dated 24/2/2026 passed by the principal and by the Court of the Learned Principal District and Session Judge, Bhagalpur, on an application instituted by the petition, suspending the conviction of the petitioner under section 498(a) of IPC. Where is your communication placing this before the authorities?
Your Lordships, this I have not placed, Your Lordship.
It is submitted by the petitioner that the order dated 24/2/2026 has not been furnished to the respondent authorities, inasmuch as the same was a development taking place during the pendency of the present petition. So, the Learned Counsel for the petitioner has submitted that in pursuance to the order dated 24/2/2026, the conviction of the petitioner being stayed, the basis for passing of the order dated 16/12/2025 has been removed, and accordingly, the petitioner is entitled to be reinstated in his services. Mr. K. Gogoi, Learned Counsel, Learned CGC, appearing for the respondents, have submitted that the respondent authorities, while passing the order dated 16/12/2025, had proceeded in the matter by considering the fact that the conviction of the petitioner under section 498A by the trial court was not suspended as on that date. He submits that the respondent authorities have not been apprised of the subsequent passing of the order dated 24/2/2026. Accordingly, he submits that the petitioner be granted a liberty to approach the respondent authorities by way of filing an application seeking for a review of the order dated 16/12/2025, basing on the subsequent order dated 24/2/2026 passed by the Court of the Learned Principal District and Sessions Judge Bhagalpur. I have heard the Learned Counsel for the parties and perused the materials available on record. On a perusal of the order dated 16/12/2025, this court finds that the same was so passed basing on the order dated, basing on the conviction of the petitioner by the trial court and the order dated 23/9/2025 passed by the appellate court in the criminal appeal instituted by the petitioner. The appellate court not having only suspended the sentence awarded by the trial court to the petitioner, the conviction being in force, the dismissal of the petitioner from his service is found by this court to have been so issued in terms of the provisions of the rules holding the field. However, a development material to the claim made by the petitioner had occasioned when the Court of the Principal District and Session Judge Bhagalpur, on an application filed by the petitioner, had proceeded wide order dated 24/2/2026 for the reasons assigned therein to suspend the conviction of the petitioner along with the suspension of his sentencing. The respondent authorities have, as contended by the Learned Counsel for the petitioner, the said order dated 24/2/2026 has not been placed before the respondent authorities. So accordingly, the respondent authorities have not considered the issue in the light of the order dated 24/2/2026. Also, in view of the above position, while not interfering with the order dated 16/12/2025, the petitioner is directed to approach the Director General of the Force by way of an application praying for a review of the order dated 16/12/2025, basing on the suspension of the conviction of the petitioner effected wide order dated 24/2/2026 passed by the effected wide order dated so and so by the Court of the Learned Principal District and Session Judge Bhagalpur. Also, the Director General of the Force, on receipt of such a representation along with a copy of the order dated 24/2/26 and a certified copy of the present order, shall give a due consideration to the same, and thereupon consideration upon the same. The Director General shall also consider the fact that with the passing of the order dated 24/2/2026, the conviction of the petitioner, although not obliterated, has been kept in abeyance. Also, accordingly, and a speaking order be passed by the Director General of the Force within a period of 30 days from the date of receipt of a representation along with the certified copy of this order and the order dated 24/2/2026 passed by the Court of the Learned Principal District and Session Judge Bhagalpur, from the petitioner. So, the order dated 16/2/2025 shall stand superseded by the further orders that would now be passed by the Director General of the Force in pursuance to the directions passed herein. Yes, Mr. Das.
My lord, last occasion and that previous occasion also there was a direction to. Your lordship may pass over a matter for time being. Mr. Goswami is on legs in court number 19, so who is coming?
Next round of call.
In this matter, notice was issued by some default, maybe my lord, that extra copies are not served to us.
Again, we have your lord.
My lord will
I can file, give one more your lordship, but
extra copies, my lord. When extra copies is served, my lord, usually we have that note, my lord.
That normally sometimes it is not filed.
so far as when official respondents are served, that is not filed.
It's not filed. You want
Otherwise,
some time.
We need some time, my lord. We have to file affidavit, my lord, in this. This is coming up for the first time after notice, my lord.
But this notice was of 2/4/26.
Yes, my lord.
Then
In between, there was summer vacation also, maybe, my lord.
forget
because
that summer vacation we have forgotten.
No, my lord, I am on the extra copy, my lord.
You give him two extra copies.
today itself.
Mr. Art Learned, additional senior government advocate, submits that he be granted further time till 14/8/2026 to complete his some instructions and apprise this court of the stand of the respondents with regard to the claim made by the petitioner in the present petition. It is provided that the registry to list this matter again on 14/8/2026. Deemed suspension, interesting issues have come up here, no order.
Deemed suspension.
There is no order. You are getting subsistence?
Yes.
So that again will come, but say in our rules, there is a line on an order passed by the appointing authority. Deemed suspension 48 hours is okay, but there is a further requirement in our rules. Kindly try to address this court on that also. Otherwise, deemed suspension, you don't require an order. You can make an argument that because now he is paying his subsistence allowance, so that is regularized. But the 6(2) requires an order to be passed. Yes. Minimum scale of pay.
Yes, the
No regularization
division
pay.
bench order was there, specific 10 years was fixed. The order, now they have
Yes.
come up by the AFRBM part, which was never there. That is where I am
Any
challenging.
affidavit filed?
No, they have not filed.
Lordship, this prayer needs to be amended because they have prayed for benefits under Retapil 45 of.
You forget that there is Jagjit Singh, we will follow Jagjit Singh. This is none of prayer is for me, I'll consider. You take your objections, but why is the affidavit is not filed?
Lordship, some time may be given.
Some time only, that is only we are giving you BTC from the long time. But we are not getting any response from your end.
Lordship, 26 matter, my lord, some time. may be
26 means what? This notice was issued on 13/5.
Yes, ma'am. Lordship, since open task has been set aside and prayer was made, in the petition matter, prayer has been made on the.
You forget the prayer. I only want you to answer to the facts.
Yes, my lord.
Prayer is for between me and him. We'll see.
Lordship.
You take your objection in your written statement or in your affidavit that this is not maintainable because of this. Other than you can't require him to amend the writ petition for filing of an affidavit. When? Give me a date.
Lordship, 3 weeks time may be given, madam.
You give me a date. Otherwise, 25,000 for filing of the affidavit.
Lordship.
And we will pay this amount to the petition.
Lordship may fix it on 21st of 21st.
Ms. B. Bora, Learned Standing Council, BTC submits that the affidavit on behalf of the respondents, BTC respondents, would be without fail filed on or before 21/8/2026. Registry to list this matter again on 28/8/2026. No further adjournment shall be granted to the respondents in the BTC for filing of the affidavit. In the event the said affidavit is not so filed, this court on or before 21/8/2025 for filing of the such affidavit. Thereafter, this court would on the next date of listing prescribe a cost for the purpose.
Here my promotion has not been given effect to madam. Page 23, madam, as per the DPC, madam, DPC was held on 10/4/23, madam. And the promotion order is of 4/5/23, madam. But madam, after that, madam, 10/5/23, madam, I have been arrested. But
Your order is of the selection was on?
But selection 10/4/23. And
Order issued on?
4/5/23.
Your suspension?
Suspension on 16/5/23. Arrested on 10/5/23. I have been reinstated, madam, on 27/12/23. So cause issued on 24/8/23.
24/8/23.
So for
you reinstated on
27/12/23.
12.
Yes, madam. And the charge sheet in so far as the criminal case is concerned, madam, it was filed on 27/12/24, madam.
27/12/24. Yes, that's good, sir.
Lordship may allow me to file an affidavit, Lordship. I have.
You have got your instruction.
Lordship.
Why was this affidavit not filed?
Lordship, I'm
on
sorry.
14/7?
I'm sorry, it is my fault, Lordship.
How much cost?
Lordship,
This is not a joke, Mr.
Lordship, I'm not laughing.
This is not a joke.
I'm serious, Lordship.
Then
I'm serious.
we have been granting you time on 1/6/18/5 notice issued, 1/6 time granted, 10/6 time granted.
By a week time, I'm filing.
No. Now if you file, we'll have to impose a cost. Tell me how much. This is which department? Irrigation.
Lordship.
Irrigation is a rich department. Yes. And that will be recovered from the officers who had defaulted in filing, giving you instructions in time.
Lordship may not do so. Lordship, I'm filing my affidavit, Lordship. This is
Tell me how much. 50,000? Exemplary cost.
Lordship may not. Lordship impose any cost, Lordship.
Why? Why should I not? Because you have taken time that you will file it on 14/7.
Lordship. It is my fault, Lordship. Lordship want to impose any cost, Lordship. It is
on you. Then it will be much higher. It will be in lakhs. Department I can go with thousands. But when it is Upadhyay, it will be lakhs.
Lordship may not.
A last chance is granted to Mr. N. Upadhyay, Learned Standing Counsel, Irrigation Department, to file an affidavit on behalf of the respondents represented by him. The said affidavit be filed on or before 7/8/2026. No further adjournment shall be granted for filing of the affidavit by the respondents. Also, petitioner may file a rejoinder thereto on or before 21/8/2026. Registry to list this matter again on 28/8/2026.
Right.
Please, your Lordship. Lordship, we have filed our affidavit in opposition on behalf of respondent number 7, Lordship. Although we filed in the morning, the same could not be brought on record, Lordship.
Okay.
May it come day after tomorrow, Lordship.
Huh?
May it come on day after tomorrow, Lordship.
Why? We had granted you time. You get it called.
We have mentioned in the morning, but the same could not be brought on record.
You bring it.
2 o'clock,
Hey,
Lordship.
Have you given a slip?
Yes, Lordship.
Get it? That means that you have got your copy.
My lord, I have just now.
Go through it. Anything there?
My lord, that is, my lord, the same documents that has been, my lord, on the earlier occasion submitted by the IS.
No, what is that in the, has he disputed the document brought in the writ petition?
Yes, my lord.
He
They
has
have disputed. They have, my lord, annexing the same documents and the same instruction that has been given by the IS. But so far as my lord,
in terms of the directions passed by this court, earlier, The respondent number 6 has filed.
Respondent number 7, Lordship.
7 has filed an additional affidavit in the matter today. Who is respondent number 7?
7 is the Hindi teacher, Lordship.
No, we wanted the affidavit from respondent number 6.
But he could not be contacted, Lordship. Even my client has tried, Lordship. They lives in
Well, then
Majuli,
we will
Lordship.
get him arrested and brought here. Or let the,
Lordship.
yes. Why the affidavit has not been filed?
Lordship, there is flood condition even in Majuli, Lordship, in low-lying areas, Lordship. He could not be contacted. Even
When
my
I
client
passed
tried.
this order on 14/7, there was no floods.
Lordship,
Floods came thereafter.
Lordship, I do not have to say anything on part of respondent number 6.
Are you appearing for respondent number 6?
No, Lordship.
Who is
I'm
appearing
appearing on
for
a- behalf
Yes, why the
of respondent
affidavit
number
was not filed?
Lordship, we tried to contact our, but we are not being able to contact him. We have not seek any further instructions on this matter.
We've been asking you to do this from 13/7, 14/7. And even after that also. And Mr. P. Monto undertook that he will file the affidavit.
Yes, Your Lordship, but we are trying to contact him, but we are not getting him.
Because of floods.
Yes, Your Lordship.
It is submitted on behalf by the learned counsel for the respondent number 6 that the respondent number 6 on account of the flood situation is not in a position to. The learned counsel for the respondent number 6 has submitted that the respondent number 6 could not be contacted on account of the flood situation prevailing in the area where he resides. It is prayed that the matter be taken up on, give me a date. And if you don't file, we are getting him here. We're hauling him in here. Now the flood situations have.
Next week, Your Lordship.
Next week will not be, let it be on 28/2026. In the event they said affidavit is not filed on or before 28/2026, this court would proceed to dispose of the writ petition basing on the materials already available on record and would draw adverse presumption, would pass orders as would be appropriate in the matter. Also, register to list this matter again on 28/2026 for further hearing.
Obliged, Your Lordship.
Obliged.
Peace, peace.
May it please your lordship. Matter pertains to my lord, regulation of contractual workers, my lord, who are working at Namrup Thermal Power Station, my lord. In this case, my lord,
So we have received the instructions, Lordship. A week's time may be granted to us to file.
Why are their services not being considered?
Lordship, they are engaged through labor contractors, Lordship. Outsourced, Lordship.
They did not participate in the selection process.
No, Lordship, no, Lord. They
Mr. H. Das Learned, counsel appearing for the respondents, heard Mr. B.K. Sharma, Learned counsel for the petitioner, also heard Mr. H. Das Learned counsel appearing for the APGCL authorities. Mr. Das submits that the instructions in the matter has been received and an affidavit on behalf of the APGCL authorities would be filed on or before, immediately, whenever it's convenient.
Lordship, 10th of August, Lordship.
On or before 10/8/2026. You will want 1 week time, Mr. Das Sharma, to file a rejoinder?
yes.
The petitioner is granted time till 19/8/2026 to file a rejoinder in the matter. Also, register to list this matter again on 24/8/2026 for admissions.
Obliged.
Obliged. My lord, may kindly take up this matter in the second half, lordship. Arguing counsel, Mr. H.K. Das is on legs, lordship. Please. Deeply, please.
They filed one affidavit, my lord.
You want to file?
They already filed, my lord.
They are filed, okay. Any
We'll respond
reply?
to that.
It is submitted by Mr. S. Dotto that the respondents in the bit, respondents have filed an affidavit in the matter. It is not on record, but
No, Lordship.
Filed on 17/7. I have received.
It is not brought on
Maybe.
record. On 17/7/22 in the writ petition or in the content.
Read petition.
Additional affidavit we have
Okay,
filed,
okay.
and it is on record, most
It's on.
lordship, yes, lordship.
Filed that additional affidavit on 21/7/2026. He prays that he be granted 2 weeks time.
2 weeks.
To file a rejoinder date. Also, pray accepted, registered to list this matter after 2 weeks. On a date to be fixed by it. In the meanwhile, the petitioner shall bring on record his, shall file a rejoinder to the affidavit, additional affidavit filed by the respondent. Yes.
Obliged.
Hello.
May it please,
Yes.
the violation is at page 62.
Yes.
It is
Mr.
dated 20.
Your
My lord,
lordship, we have
one-
filed our
one-
affidavit.
One aspect I would like to point out, this judgment is dated 26/7/24. And the judgment says, the present employer, page 62, the present employer, namely the local urban bodies where the petitioner's services have been handed over, are accordingly directed to immediately release their pending and current salaries. Now, since 7/24, where will these people go? People have stopped coming to the court, my lord. I'm just pointing out before this, where will the people go? And these officers are not doing anything. So what I pray, my lord, your lordship will call these finance officers, urban officers and municipality officers to come to the court and sit there, because they will not do anything. They don't know how to do. People will stop coming to the court, my
Yes,
lord.
Mr.
Where will they go, man?
Your lordship, in our affidavit at paragraph 6 and 7, we have stated that we have paid some of the arrear salary.
You have not paid. That is not the requirement of this court. This court requirement is all pending salary.
All pendings regarding all pending salary.
Where I only know this is a contempt. I don't know anything else. I
It
only
is
know
not
the-
deliberate, your lordship.
Huh?
That is not deliberate, your
Then
lordship.
we-
Because
we don't understand deliberate or violate.
Your
You are
lordship, we have-
violating this order, that is deliberate.
Your lordship, we have wrote a letter also to
We-
the
we
housing
don't know.
department,
We don't know.
because there is a
You sell your assets, pay them.
there is a provision also.
You sell
to-
your assets, pay them. This is the order of this court. This has attained finality.
And
My lord,
thereafter,
it says,
on-
my lord, we can move to the finance department and all this thing. I think the municipality has moved to the finance department. They're just sitting over the matter. It is their own policy that the urban areas, these employees from the urban areas will go to the municipality. Then thereafter, they're just not paying. I'll read this paragraph again, my lord, if your
No,
lordship
I've got
allows
it,
me.
Mr. Das.
It
Yes,
says
what
that
do you
the
say?
state
Who
government
is
in the
appearing,
housing.
Who is appearing for the other respondents?
The finance department was there. They sometime appear, they sometime don't appear.
Lordship, we have been appearing all the time. Please, Lordship.
Yes, what is your stand?
Lordship, here regarding, they were supposed to send a proposal for grants in it, Lordship. That otherwise the salary they were supposed to pay. So we had made the statement last time, let them make a proposal, we'll consider for grants in
My
it.
lord,
if they
these
need
things
the
cannot
proposal
go
has
in
come.
this manner.
No,
my
Lordship.
Yes,
That was the case, Lordship.
Why the proposal has not gone?
letter also.
You forget the letter. Where is
Yes.
your proposal?
Proposal
Letter
to
and
the urban-
proposal are two different things.
And in the year 2023 itself, we have already,
That is
Oh.
gone. Where is your follow-up?
we have stated that in our affidavit also.
Who is the authority to look after all this? Who is looking after in your thing? Who will be in a better position to explain?
My lord,
What are the
urban
steps
area.
being
Your lordship, then let my senior come and he'll address this.
We want it now.
Then tomorrow,
No, today, now.
today. is
Why
not-
what is this stand? Just
And,
writing a letter and sitting over the matter will not do. Where is the persuasion made by you with the finance department for the grants in it?
As per this letter dated 2008,
You are hearing the Lana Council for the parties. This court directs the, what is this municipal board? Silchar.
Silchar Municipal
Silchar
Corporation.
Municipal Board. Who is the authority? The
Your lordship, the executing officer.
the executive officer. Silchar Municipal Board
Corporation now.
place on record a list of dates highlighting the steps taken by the Silchar Municipal Board with effect from the date of passing, with effect from 26/7/2024. That is the date the order was so passed by this court in WPC number
1989, 23, my lord.
1989 of 2020.
3.
2023. 22. 1989 of 2023 and other analogous matters. Also, the executive officer, along with the set list of dates, shall enclose the proposals, communications made by it with the government in the municipal administration department as well as the finance department. Any proposal submitted for grants in aid by the said municipality before the finance department shall also be placed on record. Also, let the said instructions be placed on record through Mr. S. Dr. Learned Counsel, appearing for the respondent number 3 on the next date of listing, that is on next date of listing, full stop. Registered to list this matter again on 7/8/2026.
7/8.
They will make the proposal to the Department of Housing and Urban Development. That
Finance proposal to
Housing and urban.
proposal for grants in it to the housing and
Urban development.
urban development.
My lord, what I was submitting, my lord, all these 3 officers, they should appear before the court and
Let us
sort
see.
out.
Just
Because they
let-
don't know anything, my lord.
Mr. Das, let me just get the complete
My lord, I leave it to your lordship.
and then we will pass the.
July 24, my lord. Your lordship, these are all great for employees. Where will they go, my lord?
Mr. Das, we are there, don't worry. But let us do it in our way.
My lord, your lordship will do it. Get here. 7.
Speaking.
But Mr. N.C. Das, Learned Senior Counsel, assisted by Ms. M. Devi, Learned Counsel for the petition, review petition. The present review petition has been instituted praying for review of the directions passed by this court-wide order dated 27/5/2026 in WPC number 7183/2026 insofar as it concerns the present review petition. The review petitioner in the review petition has contended that he had appeared in the Part 3 in his BA Part 3 examinations in the year
2013, Lord.
2013. However, a wrong projection was made before this court by the controller of examinations that the petitioner had not appeared in his said examination, and accordingly, the university authorities were not in a position to declare his results. Also, issue notice, Mr.
R.A. Sheikh.
R.A. Sheikh,
On behalf of
Learned Counsel, appearing on behalf of Mr. P.J. Fukan, Learned Standing Counsel, Gauhati University, accepts notice on behalf of the respondents number 1, 2, and 3. Petitioner to take steps, no formal notice, petitioner to take steps for service of notice upon respond number 4. Register to list this matter again after 4 weeks on a date to be fixed.
Public.
The container fixed for returnable date, my lord. Respondent regarding.
I'm appearing on behalf of respondent number 1, Lord.
Ms. M. Kotoke heard Mr. C. Goswami, Learned Counsel for the petition. Also heard Ms. M. Kotoke, Learned Counsel for the respondent number 1 and 3. Office note dated 23/7/2026 submits reflects that the service of notice upon the respondent number 2 is not complete. Notices upon the respondent number 2 was issued on 8/5/2026. Also, accordingly, Ms. Kotoki, you are appearing for whom?
I'm appearing for respondent number 1, Lordship. Respondent number.
Chairman, state level.
State level chairman.
Chief Secretary.
Yes,
You are
Chief
appearing for
Secretary.
Chief Secretary.
Chief Secretary.
You are no longer in the veterinary department.
Yes, I'm in the veterinary department.
2
but,
and 3?
Respondent
Three I am
number 2
applied
is
for.
3 is not like it. Likha, police.
3.
C. Goswami heard Ms. M. Kotoki, Learned Counsel for the respond number 1, and Mr. A. Cholia, Learned Counsel for the respond number 3.
Lordship, another important thing, one speaking order has already been passed in this matter.
Order has been complied with.
Complied.
Give me, show me.
It took. in one matter. Other covered matters are fixed after 2 weeks. per
May
lordship.
serve a copy to me, madam, on next day I'll. But they have.
এইটুকে sorry.
I'll consider personal disposal of.
Dispose of কৰিছে, দিবলৈ কোৱা নাই আমাক।
He decision হৈছে. Decision হৈছে, post line.
They have considered it, rejected it. So you'll have to file,
They may challenge this order, Lord.
Give a copy.
A copy there, we'll have it in the second.
Oh, copy এটা কৰি দিবি।
You give him a copy, we'll have it in the second.
Lordship.
Mr. Goswami in the second, we just go through it. I think you'll have to challenge this.
May I please, Lord?
Heard Mr. S.A. Ahmed, learned counsel for the petitioner. Also, heard Mr. K. Kolita, learned counsel appearing for the opposite party. The present interlocutory application has been instituted, praying for impleading the opposite parties number 6, 7, 8, and 9 as respondents number 6, 7, 8, and 9 in the connected writ petition. It is projected that the said that the parties now being sought to be impleaded in the connected writ petition are the selected candidates, and without their presence, an effective order would not be permissible to be passed by this court in the present writ petition. Also, Mr. K. Kolita, learned counsel appearing for the opposite party number 1, 2, 3, 4, and 5 does not object to the prayer of the learned counsel for the learned does not object to the prayer made by the applicant in the present interlocutory application. Also, I've heard the learned counsel for the parties and also perused the materials available on them. The opposite parties number 6, 7, 8, and 9, who are now being sought to be impleaded in the connected writ petition, are found to be the selected candidates, and accordingly, the said opposite parties are proper and necessary parties in the connected writ petition, and accordingly, the petitioner is permitted to implead them as respondents in the connected writ petition. With the above observations and directions, the present writ petition, the present interlocutory application stands disposed of. So, in view of the order passed today in I bracketed C 2203/2026, permitting the petitioner to implead into 6, 7, 8, 9 less than 1, 2, 3, 4 query, but a Roman 1, Roman 2, Roman 3 as party respondents number 6, 7, 8, and 9 in the present writ petition. Petitioner to file amended cost title within 2 working days from today. On the petitioner to take steps for service of notice upon the newly impleaded respondent number 6, 7, 8, and 9 by way of speed post. Steps within 3 working days from today. Registered to list this matter again after 4 weeks on a date to be.
Obliged.
Yes.
Director of Health Service should have been the party, my lord, instead of Director of Health Service, my lord. The Director of Health and Family Welfare was typed.
No. There is a mistake. The present interlocutory application has been instituted in WPC number 3676/2026. However, along with the present interlocutory application, the records of WPC number 1866/2026 has been annexed, has been tagged. Also, registered to detach WPC number 1866/2026 from the present interlocutory application and list the same along with WPC number 3676/2026 on.
I have not been able to submit the copy, madam, because of
on 37/2026.
May I please, Your Lordship?
Hmm.
Lordship, pendency of this.
I remember on the last date you saying that there is a stay order. Show me that stay order.
Stay order, man?
You said that there is a stay order staying the earlier two advertisements.
No, I didn't say that.
You said.
No, my lord.
Then what is the purpose of this?
So, these two newly issued advertisement.
This will also be subject to
Lordship,
the
that
outcome.
too without filing the case. On 17th, he submitted that he has filed one interlocutory application, whereas in reality, Lordship, this is on 28th of July.
No, my lord.
Upon hearing the learned counsel for the parties, it is provided that the present interlocutory application shall be considered along with the connected writ petition being WPC number 3566/2025. Any recruitment made in pursuance to the present to the advertisements involved in the present writ petition. A present interlocutory application would be subject to the outcome of the writ petition being WPC number 3566/2025.
But Lordship, one thing that I just want to say, that advertisement, Lordship, anyone can apply. There is no such bar.
No, what did I say? It's just subject to the outcome. You'll hear it on registered to list this matter again on 6/8/2026.
6/8.
No, already the matter is fixed on 6/8.
That's what I said. It's
Yes.
6/8. Regular?
I appear for the private response.
Also, Mr. D. Bora, learned counsel appears for the respondents number 4 and 5.
Obliged, my lord.
Obliged, your Lordship.
Itu mati dia na, he funded to this. Arunachal. Itanagar, sorry. Dutar नहीं गया. यार लिखा ना इसमें. Oh, Duta was away. Pending kita मतलब.
Look, the item 57, if Lordship may take up.
We'll take it up. Motion kita man pakki usiru. Just have a few motion matters. We'll just finish it up and then take up 57. Yes. Yes, Mr. Bhar, what is your instruction?
My lord, this is for motion, my lord.
No, we have required you to receive instructions last week. 13/7.
My lord, at this moment, don't have any instruction, my lord. My lord will grant me 10 days time.
Say, this is already admitted. Why is the one not released? Mr. Dhar, Learned Standing Counsel, Public Works Department, submits that he be granted further time till 12/8/2026 to complete his instructions in the matter as to why the area salaries of the petitioner has not been released to him. Pray accepted, registered to list this matter again on 12/8.
Well,
2026. Huh? नहीं, ये मत आओ। Motion review. 5857 tomorrow. That review petition has come. But even if it is not recorded, Mr. Soikia, we remove
Lordship
what
was
we have
pleased
said.
to, I have just seen the whole video. A detail about 7-8 pages long judgment was, order was
No,
passed.
that I deleted because of the changed circumstances.
Because after that I left because Lordship was.
No. I just, because of the whole.
I leave it to your Lordship because when an order is delivered, we consider that is the final order.
No.
But it was not signed. I understand.
But thing is, I clearly remember.
I leave it
that
now. That's why I am not making any submission.
Keep it in me. Don't worry about it. Yes. Have you received the, you are not taking an.
At 11 o'clock, Lordship has directed in that order. Why I am saying, Lordship said that by Saturday, you will give a soft copy to the other side. We have received the hard copy at 11:30 today.
So thereafter, my lord, the discussion was held that Saturday and Sunday, the office will remain closed. So that's why, my lord, today morning we have-
On that ground, Lordship directed that serve it in soft copy on Saturday.
What do you want today? Shall
Lord,
we
no,
proceed or you
Lordship
want
will
to-
hear them.
No, you want to have a instruction in the matter or you have?
Definitely, Lordship. If they are pressing it, we'll have to seek
Because
instruction.
they'll be
Only
pressing
thing, I'm sorry.
Mr. Das, are you pressing that interlocutory, that contentions that you have now raised in your?
Yes, my lord.
Then we'll have to give.
No, just one explanation, my lord. So far as this contention with regard to granting NOC to the other officers are concerned, that is an admitted factual position that your lordship will find from.
Mr. Das, what is the circumstances under which it was so granted to them? Do you have materials to reveal that?
Circumstances is not relevant. That is my submission is, my lord. My lord, my submission is that.
Okay, make your.
My lord, my submission is that 3 officers
Where is
were
your
granted.
affidavit? Where is your affidavit?
My.
I send.
Wait
Wait only. Yes, which is the paragraph?
Paragraph 3. Lordship got the affidavit. This is correlating to their previous affidavit, annexure R8, wherein they have admitted that NOC was issued to this 3 person. Only thing that they did not disclose that which officer is doing what course. So I found these 3 officers, 7, 8, and 9.
In A8.
7, 8, and 9, they are pursuing PhD. After grant of NOC. I am before your lordships only for grant of NOC, my lord. If they can be given, why same yardstick is not applicable in my case, and it's a clear case of serious discrimination? That is my submission, my lord. And for that.
Okay, let us see what are this chief registrar and chief administrator is doing PhD.
Head security services, then registrar come chief administrative officer, then senior faculty. These 3 officers, they are pursuing their PhD. They have admitted it. It's an admitted factual position. Only instruction they did not furnish is whether which officer is doing PhD and which is not. That I have collected from the website of the respective university and I have placed.
Okay.
And serial number. So
what were the yardsticks which were considered by the institute while granting them these permissions, NOCs?
So
and what is the ground which is not so considered in your case?
They in their affidavit they say administrative exigency. So far as I am concerned,
I'm not even.
My relief will
the
hamper.
plea of discrimination.
Yes.
How were their applications considered?
Not the factum that they were granted NOC in my humble submission is sufficient because those posts are also single cadre posts. That your lordship will find from the gazette notification page 313.
$300?
313 gazette notification, the post in the institute. Relevant portion 316. Chief Administrative Officer, 1 post.
Where?
316 part C. Administrative post and other staff. Then Head Security Service, 1. Mine also 1, my lord. Senior engineer. So Chief Administrative Officer.
And where is the senior design?
Senior design, your lordship will find The designation has been changed. Page 315,
Hmm.
6th post.
Which is the one?
Serial number 3.
Hmm.
So an officer holding the post of such importance like Chief Administrative Officer and Registrar, if that officer can be granted NOC.
So only what 2 persons are holding single categories?
Yes, these 2 persons, Head Security Service and Chief Administrative Officer, are holding single cadre post. And Chief Administrative Officer, it's a tremendously important post. Some registrar. Both the posts are single cadre posts. Be that as it may, prima facie, what I am trying to submit before your lordships is that, my lord, I am entitled for the relief. That is my case. And these are admitted, these are apparent on the face of the records, my lord. Under what circumstances they were granted, what consideration was there, if they come up with a stand that the Chief Administrative Officer and the Registrar doesn't have work to do, and the senior engineer has so much of work, that I have nothing to say.
Okay.
But if your lordships wants to see the work of the Chief Administrative Officer, that I can show to your lordships from their last affidavit filed. Registrar and Chief Administrative Officer.
Page?
Page would be, my lord, 153 is the, 54 is the registrar's job description. And 158 would be the job description of the Chief Administrative Officer. Function as HOD of establishment personnel, general administration matter, including contract management. Possible job description of registrar and CA.
And from when is she holding the post of registrar and CAO?
When my case was rejected, she was holding the post.
When she was deputed, was she also holding the charge of CAO?
Yes, my lord, the note sheet itself, I'll just.
No. When she was nominated for undergoing herself, when she was given the permission, was she also holding the charge of CAO? Yes, where is the next one? Security?
Head security, lordship will find.
Because registrar and CAO seems to be 2 different posts.
2 different posts. Page 160.
What is this post called?
Head security services, 160.
Head security services. Yes.
And their impugn note itself give an impression, my present work. Page 147, if my lord takes up.
Of the same affidavit.
Same, my lord, voluminous affidavit. This I have reflected in my reply also, my lord. Whereas the assignment of Adhikari at the institute is routine maintenance and overview of third-party execution of work for which PhD is not necessary. That while indicating necessity of PhD, they have said so. So I am presently, these two are the works that I am
Where are you reading?
page 147, the paragraph that start with the rules for permission.
The rules for permission, no?
Yes. Last three lines, whereas. So at the time of consideration, my lord, these were the two works as per them, for which, my lord, PhD is not necessary.
No,
But
there
at the
is
same
the
time,
work profile in this, your work profile also is somewhere here.
but I am, my lord, what my submission is that, my
No,
lord, I
your
am
submission
indicating
may-
this. I am,
Where is that work profile of the land management thing in this? There was somewhere I just saw it.
Work profile is 30 of the.
No, in your this reply, I just saw somewhere.
yes. I'll just indicate, my lord. As per the post creation, the page 175. In the same very
Okay.
in the
Anything
same
more?
very chief administrative officer and registrar repeatedly, lordship will see the note sheet, repeatedly refused NOC to the petitioner, persuaded the director to grant NOC to the petitioner, and she herself is doing a PhD by obtaining NOC. They have stated in their affidavit various, my lord, stipulations which are to be considered while granting NOC, my lord. My humble submission is that, my lord, those stipulations are also applicable to the other officers, my lord.
We'll see how it was.
And there is no rule, statutory rule or guidelines or instructions of the department
regulate
to
this.
refuse me NOC on the grounds urged by them, except for this administrative exigency. And this ground of administrative exigency, my lord, in my humble submission, appears to be non-existent and perverse. That is another limb apart from the discrimination, my lord. That is precisely my submission, my lord.
Lordship, this affidavit is trying to bring the issue of discrimination under Article 14. And he has referred to some names. Lordship will kindly come to the affidavit.
Affidavit filed by the
Yes.
petition. Yes. Para?
Paragraph 3. I would like to place it first. That with regard to the averments made in paragraph 2 of the additional counter affidavit, the answering deponent, while denying the contention made therein, begs to state that hampering, affecting of work of the institute has been urged for the first time by the respondent as a reason to refuse NOC to the petitioner by producing note sheets along with the instant additional counter affidavit. Neither the impugned order dated so and so nor the detailed affidavit filed by the respondent on 25th May contain the reasons that grant of NOC to the petitioner would hamper the work of the institute, who is holding a single cadre post. This is his submission. This coining of the word single cadre post is not our statement or neither our the word which we have used. However, from Annexure R8 of the affidavit in opposition filed by the respondent, the RTI reply dated 6/1/2026, it has been gathered and it is an admitted factual position that serial number 7, 8, and 9 in the said reply have granted NOC by the respondent despite holding single cadre post. Now, this is his finding. Serial number 7, Sunil Kumar Bonia, Head Security Services, pursuing his PhD from the Assam Kaziranga University in Management, which can be gathered from the notice dated 10/2/2026. Serial number 8, Dulumoni Kolita, Registrar and Chief Administrative Officer in charge, is doing her PhD from the Kaziranga University in Management, which can be gathered from the notice dated 31st July 2025. And serial number 9, Sukriti Saha, Senior Faculty, is pursuing his PhD from Tezpur University in Design, which is discernible from the notice dated 12/12/2025 and the subsequent notice dated 8/1/2026, enclosing the provisional selected candidates for admission in PhD program in spring semester 2026. Since the respondent did not disclose the name of the courses applied by the 3 above officers against NOC granted to them in the RTI reply, the deponent is placing on record the details of the respective PhD courses which they are pursuing. Therefore, action on the part of the respondent in denying NOC to the petitioner and at the same time granting NOC to serial number 7, 8, and 9 of the RTI dated so-and-so is highly discriminatory, as in clear violation of Article 14, 19, 21. Further, going in the same paragraph, further the deponent begs to state that purported ground of administrative exigency to deny NOC to the petitioner is also totally non-existent and perverse, which can be gathered from the note number 20 itself, where the registrar and CAOIC admitted the petitioner is presently assigned with only routine maintenance and overview of third-party execution and nothing else. So these two very important words he has used: routine maintenance and overview of third-party execution, which is a part of the note sheet. Be that as it may, it is explicitly clear that as on date, there is no pending work with the petitioner, and vis-a-vis serial number 8, 7, 8, and 9 to deny grant of NOC. So this is not an admitted fact, Lordship. What is pending before him, what is pending before the other persons, we have to verify. The malice in law is writ large, as in as much as the registrar comes CAOIC, despite holding a single cadre post, having whole lot of recurring works, had been granted the NOC for doing PhD, and the same officer repeatedly denying NOC to the petitioner in her notings by citing non-existent reasons. Now let us go and read note 20 again, because in nowhere we have stated that because of the single cadre post, he has been denied. From where that idea has been conceptualized, Lordship, it is a mystery now. Lordship will take that note. May I read that note now? Requirement, note number 20. Requirement of prior permission NOC for higher education from the serving department is a prerequisite and is not concerned with NOC sought by the university where the concerned person wishes to pursue higher education. So, the logic given by Mr. Adhikari that he did not seek NOC as it was not asked by Tezpur University cannot be accepted. The explanation given by Mr. Adhikari towards completion of his assignment is devoid of actual picture. The work to prepare estimate for repair works of the institute with DSR 2023 was given in August 2024, where his estimate came to 38 lakhs approximately, which he did in March 2025, that is after 2 years, and that too only after direct intervention of the director. As regard to his assignment of mutation of land is concerned, the same was not completed by him, even after repeated instructions, and finally undersigned completed the work. So the other person had to take it over. The rules for permission for higher studies clearly mentions that the function of the post and the qualification proposed to be acquired must have a direct bearing, and that it should contribute to the efficiency of the government servant. Whereas the assignment of Adhikari at the institute is routine maintenance and overview of third-party execution of work, for which PhD degree is not, I'm skipping that point. When he was previously allowed to pursue MTech program in 2022 to 2024, His productivity and performance in office had considerably lowered as reflected in his APRS. Further, as per UGC guidelines, the presence in the station of the university during coursework or of at least one semester is mandatory. And as Tezpur University is far off from Jorhat, station leave of nearly 6 months would be required to complete the course, which invariably would affect the institute work and also his previous record. From his previous record, it can be inferred that his own efficiency towards NID Assam works would be lower during that period. So it would affect the institute's work. In view of above, it is proposed not to allow him permission NOC for PhD program at Tezpur at this stage, and 21, note number 21, as per the analysis seen, it is decided to postpone the application for future, may not be allowed this time. So where is the issue of single cadre post here? There is no such. This is a concept promoted and visualized by the other side. It is not our case that because of the single cadre post, we have denied him. It is not. Therefore, he is equating the case of single cadre post of serial number 7, 8, and 9 in my humble submission has no legs to stand. It will fall flat. There is no justification, no reasoning to equate the writ petitioner with serial number 7, 8, and 9. That is 3 persons' name which he has incorporated in paragraph 3. So it is not that reason. The reason is very clear and plain and simple that it would affect institute's work. Number 1, his previous permission showed that his efficiency declined. He could not finish 2 of the major works because of the interference of some other persons. Those could be done after 2 years. And his presence in the institute would be required because at present there are a lot of works which are going on, like routine maintenance and overview of third party. So routine maintenance is a work where there cannot be any pendency. It's a day-to-day affair. Day in and day out, something has to be done. And to this point, which they have argued, although the affidavit does not justify that. I have a judgment of the Supreme Court. Let us assume that those 3 persons we have wrongly given. In that situation also, this Honorable Court would like to follow the principle laid by the Honorable Supreme Court in the judgment which was Chandrasekhar. Have Lordship? Yes. May I place that judgment now?
Para 10.
Paragraph 10 is very relevant. Merely because in some cases the norms have not been followed, that cannot be a ground to hold the departure from norms should be continued. These are serious allegations about the respondents having manipulated and fabricated documents.
That is not here.
No. Subsidiary, we need not go into these allegations, but as has been fairly accepted by the learned counsel for the respondents, there is no official communication from IIT Madras to support that the respondents stand that he was asked by the authorities of the state institute not to attend the program. There should have been some material to support the stand. Unfortunately, for the respondent.
So I think your paragraph would be para 9. The doctrine of
Yes, Lordship, there is a change here. Yes. Because I have read it from my thing and then now it is all.
The doctrine of discrimination is founded on
Yes,
enforceable right.
Judgment of Ram Kumar Man is referred to, Article 14 is referred to.
Because here the
But the ratio is very clear.
In these cases, the actual metrics was different. There were some.
But the ratio is
he
there.
went there, he did not join, he came back.
The Honorable Supreme Court did not look into those allegations. The Honorable Supreme Court looked into the thing that if anybody has been given at earlier instance, that kind of permission, education, study
Are
leave.
you trying to project that, okay, the institute made a mistake while giving it
To
the
other three in case.
Other three, actually two. The head security officer and the lady.
But
lady
that's
sir.
not our case here.
That even if we
have done it,
that, then that should not be permitted to be perpetuated.
exactly. So the principle of that doctrine of negative equality, it cannot be. Ultimately, to attract the mandate of Article 14, Lordship, first there must be an enforceable right from the statute, from the norms, and which in my humble submission, the writ petitioner has miserably failed to project before this honorable court. Now that is why this additional affidavit has come by citing three other cases. They are trying to build up a case under Article 14, 19, and 21. That is why I was objecting the other day. So in that view of the matter, I am placing it today, but I would like to praise this honorable court that Lordship will kindly give me some time to file an affidavit. I'm praying for 2 weeks' time to file the affidavit because we have to find out all the relevant facts and background.
Mr. Soikia, I understand. A new ground being developed, an opportunity must necessarily be given to you. And this is, I think I said, maybe it was somehow not reflected, but this is the stand. This is the law.
Law is very clear.
So, but
at the same time, I'm still submitting that the three cases cannot be equated now because those cases may be single cadre post, but that is not the criteria on the
Mr.
basis of which
Soikia,
Note 21 was
Mr.
prepared.
Soikia, the liberty is yours. If you stick to that plea, that these three cannot be equated, not three, two cannot be equated. One is a faculty. There are many posts, so it's not a single cadre post. Cannot be equated, and then you close your argument, it would be one factor, then we proceed with the matter to consider. Or you say that no, because
Now I'm saying one more thing, that his contention is that there is no pending work.
No, fine.
That also I have to justify
Fine.
with proper factual background
Fine.
and the ground reality
the
which
thing
is
is,
prevailing in
Mr.
that
Mr.
institute
Soikia,
today.
Mr. Soikia, just for the ends of justice, I'm not here for anything else. Because what has happened is we are having a timeline. We are having a timeline. And this court has already disclosed its mind that the first 2 points that you have taken, non-permission to join, and with regard to whether that degree is required or not, we are not coming into that. But the third point, that is one where we find you have some footing, if I may use that word. And that is there in your notes also. If I apply that decision of guilt, reverse manner, Gill says, by way of filing an affidavit, you cannot improve what you have already stated in the record, in the order. But here, in the affidavit or in the order, maybe it's not there, but in the contemporaneous records, your grounds are there. So it's a reverse of.
And Lordship, we cannot expect an administrative officer to write a order in the line of a judgment delivered by honorable.
I'm not, Mr. Soikia, I'm not even elevating to that.
Yeah.
I'm saying that this is a case of reverse MS Gill. Because in MS Gill, it says that you can't develop by way of filing an affidavit.
Yes.
What you have done is, in the affidavit, maybe you have not disclosed to that extent, but
in fact, Lordship, in Silpi Construction's case, in affidavit, we can give the additional grounds while rejecting or accepting a tender. It may not be there in the actual.
Let us hold a worse situation case.
The ground.
Mr. Soikia, you came in late. In the affidavit, maybe if it was settled by you, many things would have come in. But unfortunately, in the affidavit, many things have not come in. But it is there in the contemporaneous record.
And Lordship has directed that to be filed. In fact, after looking at that.
On your prayer.
My prayer, they have also added a lot of other documents which are creating all these problems now. The whole understanding only that it will be given. When it was filed, and I was also surprised.
But I did not think this to be so fat till yesterday.
Yes, yes.
This, I'm saying of the reverse of this.
Exactly.
It's a case of reverse. Here it says that you can't go to the affidavit, you have to rely on the grounds in the order or in the contemporaneous
So
records?
just for your.
Here,
lordship's
the
convenience.
affidavit, let us hold that it does not say. But the contemporaneous record says something, which Mr. Saikia is entitled to take. Now, Mr. Saikia, given this condition, a PhD degree is there, something is there. We are also to dispense justice either way, because justice does not mean only justice to the petitioner or the respondent. Either way. Can you cut short this time?
Yes, 1 week.
1 week.
Because the persons who are supposed to come and file affidavit also, their houses are also flood affected.
I can
They have to
understand.
return back.
I can understand. When can you file this affidavit?
Kindly give me 1 week's time. By next Monday, we'll file the affidavit. Tuesday or Thursday, Lordship may take up the matter.
Monday, they will file the affidavit. I'll hear this online from Arunachal, pass the order on Tuesday. You file the affidavit on Monday.
We'll file
And
it.
Mr. Saikia, if I have understood Mr. Das's argument is, he says he is not going to that extent as to how, what, he is only limiting that. See, you have given it to a person who is still holding the, if you can deal with this in your affidavit, that he is holding a very important post in the organization.
I will handle everything, Lord.
That much.
Whatever is there on the record, we will handle everything.
The respondents, that in response to the affidavit filed by the respondent, number 2 and 3, the petitioner has brought on record a rejoinder. At this stage, it is to be noted that this court, when the plea of, when the petitioner, learned counsel for the petitioner, senior counsel for the petitioner, had requested for filing additional pleadings, had made a categorical, had made a opinion, had disclosed its, had made an opinion to the effect that in the event of filing of such affidavit, the respondent number 2 and 3 must be given adequate opportunity to file their response thereto and or complete instructions on the same. So, Mr. Saikia, Mr. Saikia had objected to any further pleading be filed in the matter, considering that the petitioner itself had raised its urgency in the matter, full stop. This court, in view of the said submission of the learned senior counsel for the respondent, that had opined that in the event of any further pleading brought on record, adequate opportunity has to be granted to the respondent number 2 and 3 to file their response. Also, Mr. Saikia, learned senior counsel appearing for the respondents, has made his submissions, however, has submitted that he would be required, according, he submits that the respondent number 2 and 3 would be required to file an affidavit to counter the contentions raised by the petitioner in the present, in the affidavit in reply of a discrimination meted out to him in the matter. He submits that the plea of discrimination has been raised for the first time in the affidavit in reply filed in the present matter today. Also, Mr. Chamuha, learned counsel assisting Mr. Saikia, submits that the said affidavit would be filed on or before 3/8.
Lord, may I make a small request through this honorable court to my senior Milord? If it can be filed by Friday, Milord, instead of Monday, Milord. It's my request only
31st.
to my senior.
It is up to.
It's only my
We'll file it by 31st.
31st. On?
My lord. I'm highly
No. Friday, no. I am looking the August. So next Monday is the date. Next Monday will be
My
3/8.
request.
third.
File it on 3rd. On 3/8/2024. As this court would be holding, as this bench would be holding court in Itanagar, in Nahalagun, the matter would be taken up on 4/8/2026 online from Nahalagun at 2 p.m.
May just pray through your lordship, if can be filed on Friday, my lord, that will be helpful, my lord, to the petitioner also, my lord.
This is only a disclosure of their, your, that work thing. I think that is
My
nothing.
lord, there will not be any more pleadings from my side, my lord.
You
That
will
is
get
I'm
it on
making
third.
clear.
Mr. Shamuha will give it to you on third. So you have time till 4th, 2 p.m. On 4th, there will be no adjournment. We will hear the matter, pass the orders. So accordingly, registry to list it muk by skip we'll do it online only.
No day.
On 4/8/2026. So review petition, I think I have covered that in your, so whether this review petition.
Let it come, then we'll not press it later
No,
on.
no, I think today itself will, otherwise if you want an order, we can pass an order here, Mr. If you want to.
No, let it be kept pending, lordship. Has it come before this?
Yes, yes, it has come.
In that case, that lordship may issue notice.
No, no, I'm hearing the matter. If there is something here which has to be
Yes.
done, we'll place it, we'll do it now only.
Yes, sir. Because the tenor of this whole review application is based on the lordship detailed order. Lordship
Mr.
has finally
Sokia,
passed 5 or
as it
6 lines
turned out-
order,
as it
but
turned
it
out-
was, I cannot presume that lordship will go to the chamber and there will be a
No, no,
drastic change.
No, it was changed here only.
No, it was
This
not
order
changed.
was
It
passed
was
here.
not changed here.
Yes, yes.
No, I have the video recording, lordship. I have seen it. Lordship has passed a very detailed order which would have taken about 7-8 pages.
It was.
That is why I'm not pressing. That is why I'm saying that I'll not press.
We are recalling that order. We'll recall that order, pass a fresh order. We'll recall that order.
No, lordship. Because in that
No, no,
order,
once this,
if
this
lordship
has
is
come.
pleased to look at that video, because I completed once lordship was
Soikia, that day the things were moving at a very rapid pace.
and lordship has passed a detailed order, then I
passed the
raised the
detailed order
objection.
itself.
Lordship allowed the person who was recording it to dictate it.
This review petition has been instituted, praying for a review of the order dated 23/7/2026, passed by this court in WPC number 1730/2026. This court, while in the review petition, it has been projected that on 22/7/2026, this court, while passing its order, but this court on 23/7/2026, while taking the affidavit filed by the instant review petition on record, has submitted that on 23/7/2026, the learned senior counsel for the respondent, opposite party, respondent, number one, had urged this court to grant him time till 27/7/2026 to file his response, citing the ground of discrimination. So, in response, the learned senior counsel for the review petitioner had submitted that as the matter was substantially heard, this court would not allow any party to bring on record any further pleading which may cause serious prejudice to the interest of the other side. It is further projected that this court, while dictating the order in the open court, had affirmed that the objection raised by the learned senior counsel for the review petitioner was recorded, and the said was even read out by the steno secretary of this court. However, it is projected that in the order dated 17/7/2026, the said 23/7/2026, the said portion of the order was a said portion of the order wherein the objections and the acceptance of such objection by this court of the learned senior counsel for the petitioner was omitted. Also, accordingly, it is submitted that the said order being passed in the open court, comma, a review of said order could not have been changed. Also, by making the said projections, the review petitioner has prayed for the following relief. Page 682A. Also, on the set date of listing, this matter was being heard. And initially, this court was also reluctant to adjourn the matter, permitting the learned senior counsel for the petitioner or for the opposite party number of the respondent number 1 to bring on record any further pleadings. However, finally, when it was prayed by the learned senior counsel for the petitioner that he would file a reply to the affidavit filed by the additional affidavit filed by the review petitioner, comma, the same was allowed and the earlier order was striken off, in as much as by that time the said order was not signed by this court. However, this court provides that the filing of the affidavit today by the respondent number 1 in the additional finding of the affidavit in reply to the by the petitioner in the connected writ petition was not was with the the learned counsel, the petitioner has in the has today filed a reply in the matter, and this court at the outset had permitted the learned counsel appearing for the respondent's number for the review petitioner had asked and had inquired from the learned counsel appearing for the review petitioners as to the time they would require to file a response thereto. So, the learned counsel assisting Mr. Saikia has submitted. Learned counsel assisting Mr. Saikia, learned counsel appearing for the review petitioners, comma, assisting Mr. Saikia, learned senior counsel has submitted that such affidavit would be filed on 3/8/2024. Accordingly, the said affidavit, an opportunity having been already granted to the review petitioners to file an affidavit in the matter, comma, the non-incorporation of the objection of the learned senior counsel as made on 23/7/2026 in the order passed on that day, in the considered view of this court, would not cause any prejudice to the review petitioners. Accordingly, the present review petition is not proceeded with and the same stands closed. I think that has taken care of it. Order to Likhisane 3/8/2026 and list on 4/8/2026. Anything more?
It will be additional counter affidavit. The one they have filed, it was
additional affidavit I have said.
Additional, they named as additional counter affidavit. That much. The interim may continue.
Interim order passed earlier to continue till the next date of this.
Deeply obliged.
Now, Mr. Just give the particulars how you have done it in the two of them and the works pending. I think that will do. On 4th.
Now we'll file according to the affidavit, Lordship.
No,
whatever they have said, we'll file.
No, Mr.
If Lordship give us this indication, that is causing prejudice to the other side.
No. What I am saying is,
because they are filing affidavit, we'll counter every line, every fact.
That will.
Deeply open.
এটা ইয়ে আছিল নহয় 1 নম্বৰটো Mr. N.C. Das, Learned Senior Counsel, assisted by Ms. J. Bush, Learned Counsel for the petition. Learned Senior Counsel, assisted by Mr. J. Bush, Learned Counsel, appearing for the petition. Also heard Mr. M. Sharma, Learned Standing Counsel. It is United Bank.
Union Bank.
Union Bank of India, appearing for all the respondents. The petitioner in the present petition has assailed an order dated 2/1/2008 issued by the disciplinary authority, imposing upon him a penalty of dismissal from service, on conclusion of a departmental proceeding instituted against him. The petitioner has also assailed the orders issued towards forfeiting his gratuity and provident fund towards the amounts purportedly defalcated by the petitioner during his service in the bank. Also, the order dated 2/1/2008 was assailed by the petitioner initially by way of instituting a writ petition being WPC number 5612/2008. The said writ petition was dismissed for non-prosecution on 10/8/2015. Also, after the said writ petition was dismissed for non-prosecution, the petitioner had instituted the present writ petition. Also, on the said query being made by this court, the Learned Senior Counsel, the petitioner has filed an additional affidavit in the matter, and therein had clarified that the said writ petition being WPC number 5612/2017 was permitted to be, on restoration, was permitted to be withdrawn. Was restored by this court, while an order dated 14/6/2019 passed in IA bracketed C number 823/2019. The petitioner, in the meanwhile, having instituted the present writ petition, on a prayer made, this court had permitted the petitioner to withdraw WPC number 5612/2008, while an order dated 22/10/2019. Accordingly, this court, having found the order dismissing the writ petition wherein a challenge to the order dated 2/1/2008 was passed to have been dismissed for non-prosecution and thereafter restored and permitted to be withdrawn in the light of the institution of the present proceedings, this court while order dated 28/4/2026 passed in the present writ petition had directed that the matter would now be considered on its own merits. Accordingly, the learned counsel for the parties were heard at length and the matter is listed today for delivery of orders. So, as projected in the writ petition, the petitioner hearing had initially joined the services of the respondent number 1 bank as a clerk cum cashier on 29/10/1981. The petitioner on his joining was posted at the Nagaon bracketed B branch of Borpeta district. Thereafter, the petitioner was promoted to the officer's cadre with effect from 1/10/2003. The petitioner was also promoted to the junior management grade bracketed scale 1 with effect from 1/10/2003. Basing on certain allegations arising with regard to the discharge of duties by the petitioner, the petitioner was wide order dated 17 to wide a memorandum dated 17/2/2006 placed under suspension pending investigation oblique inquiry into the allegations leveled against him. Thereafter, wide a memorandum of charge dated 20/2/2007. The petitioner was a departmental proceeding was instituted against the petitioner with regard to allegations surfacing against him pertaining to the manner in which he had discharged his duties, and therein also allegations of misappropriation of bank funds was so leveled. The petitioner, on receipt of the said memorandum of charge dated 20/2/2007, had not submitted his written statement against the same as purportedly advised by the union officials. Also, the respondent authorities thereafter directed for holding of an inquiry into the allegations oblique charges framed against the petitioner, while the show cause notice dated so and so, and appointed an inquiry officer and a presenting officer for the purpose. The petitioner participated in the inquiry, and on conclusion of the same, the respondents, the inquiry officer submitted his inquiry report holding all the charges framed against the petitioner to have been proved. Also, a copy of the inquiry report was also forwarded to the petitioner and he submitted his representation thereon. Also, next. The disciplinary authority of the petitioner on a consideration of the inquiry report, materials coming on record in the inquiry, as well as the representation submitted by the petitioner against the inquiry report, proceeded while order dated 2/1/2018 to concur with the findings of the inquiry officer and proceeded to impose the penalty of dismissal from service upon the petitioner with immediate effect. The petitioner thereafter instituted a appeal against the said order dated 2/1/2008. However, the appellate authority had not considered the said appeal. Also, the petitioner in the present writ petition has also projected that basing on the allegations leveled against him in the departmental proceeding, so institute, comma, a criminal proceeding was also instituted against the petitioner in the form of Borpeta PS case number
314.
139 2006.
314
314?
up to 2006.
No, that is a
GR case number.
GR case number. Borpeta PS case number 139 2006. So, the police in the matter, on conclusion of investigations, submitted laid a charge sheet against the petitioner, and the case was and the trial commenced in the matter before the court of the Chief Judicial Magistrate, Borpeta, in GR case number 314/2006 under section 409 IPC. The trial court, upon considering the evidences coming on record, was pleased by judgment dated 8/4/2016 to acquit the petitioner from the charge so framed against him in the said case by granting him benefit of doubt. Also, the petitioner, now being acquitted from the criminal proceedings instituted against him, comma, had approached the respondent authorities, praying for a reinstatement in his service. Also, the said prayer not being considered, the petitioner had instituted the present writ petition. Mr. N.C. Das, learned senior counsel, by reiterating the facts noticed herein above, has at the outset submitted that the non-filing of a show cause of a written statement of defense in pursuance to the memorandum of charge dated 20/2/2007 should not be held against the petitioner, inasmuch as the said course of action was adopted by the petitioner on account of a wrong advice given to him by the union members. Mr. Das has submitted that the inquiry in the matter was conducted in a perfunctory manner, inasmuch as the inquiry was concluded after 2 days of sitting. He submits that the petition was not provided with all the requisite documents relied upon by the department for establishing the charge against the petitioner, and further, the petitioner was not permitted to adduce defense witnesses as well as documents. So, Mr. Das submits that the conclusions drawn by the inquiry officer in the inquiry report would go to reveal that the same are forced conclusions and drawn without there being any admissible evidence on record to support such conclusion. Mr. Das submits that the petitioner in the inquiry report, it has been highlighted that the petitioner had admitted to the charges, had admitted to committing the allegations leveled against him, and also of repaying the amount which was so purportedly defalcated by him from the bank. Mr. Das submits that the said statement was made on a impression given to the petitioner that in the event he admits to the same, comma, a lenient punishment would be imposed upon him. Also, Mr. Das submits that the conclusions drawn by the Mr. Das submits that the conclusions drawn by the inquiry officer with regard to each of the charges framed against the petitioner, being so drawn without affording a due opportunity to the petitioner to place on record his defense witnesses as well as defense documents, such conclusion would not be permissible to be so. The summits that the said conclusions so drawn stand vitiated, and basing on such vitiated conclusion, no penalty was permissible to be imposed upon the petitioner. Mr. Das has, Mr. Das, the learned senior counsel, Mr. Das, learned senior counsel for the petitioner, has further submitted that the allegation against the petitioner being of defalcation of money of the bank and a criminal proceeding being also instituted against him on the said ground, and in the criminal proceeding, the said charge not being proved, this court proved, Mr. Das submits that the conclusions reached by the inquiry officer in the departmental inquiry held against the petitioner would mandate to be held to have been so arrived at without there being any material for the purpose. He submits that the witnesses appearing in the inquiry, departmental inquiry, and in the criminal trial held against the petitioner being similar, the conclusions drawn by the criminal court, by the trial court in the matter, which had the effect of exonerating the petitioner from the charge so framed against him, would have to be given primacy, and accordingly, the findings of the inquiry officer would mandate an interference from this court. Anything more, Mr. Das? What's up? Thereafter, Mr. Das, by referring to the order dated, impugn order dated 2/1/2008 passed by the disciplinary authority, has submitted that the disciplinary authority had not considered the contentions raised by the petitioner
Pair number 22, 23, and 24, of the repetition,
Mr. Das has further submitted that the charges, when read in conjunction with the purported admission of the petitioner, the same would only go to reveal that the petitioner had committed certain mistakes which were not intentional and had occasion on account of the inexperience, on account of his inexperience with the works he was at the relevant point of time discharging. Also, accordingly, Mr. Das submits that the penalty of dismissal from service is clearly disproportionate to the charges level and proved against the petitioner in the inquiry. Also, Mr. Das, by referring to the order passed by the disciplinary authority dated so and so 2/1/2018 has submitted that 2008 has submitted that the disciplinary authority, without appreciating the materials coming on record in the inquiry as well as the contentions raised thereon by the petitioner, had proceeded to concur with the findings recorded by the inquiry officer in the inquiry report and thereby impose the penalty of dismissal from service from the petitioner. He submits that he reiterates that the penalty of dismissal from service as imposed upon him by the order dated 2/1/2008 is clearly disproportionate and would mandate an interference from this court. I think that will cover your
Paragraph number 18, my lord, page
18.
18, my lord. This is, these charges, my lord. It should be definite and distinct. Charges were not drawn by the disciplinary authority, my lord.
But you have never questioned this by way of filing a written statement. You have never questioned this. Even in your appeal, you have not taken any point. Okay, we'll put it. Mr. Das at the outset has submitted that a perusal of the show cause of the memorandum of charge dated so and so 20/2007 would go to reveal that the charges framed against the petitioner are all vague and on this count itself, they are all vague. Full stop. He submits that the regulations holding the field mandate the disciplinary authority to frame definite and distinct charges. Full stop. He submits that in absence of a definite and distinct charge being framed against the petitioner, the petitioner was also not in a position to submit his reply thereto. Full stop. Per contra, Mr. M. Sharma, learned counsel for the petitioner, has submitted that the charges framed against the petitioner are clear and distinct, and a perusal of the same would go to reveal that the allegations leveled against the petitioner, allegations leveled oblique charges framed against the petitioner has been so framed with disclosure of all requisite particulars. Also, Mr. Sharma submits that the petitioner, that in the inquiry held, the petitioner had admitted to the allegations leveled against him in the matter. However, he had taken a plea to the effect that actually he had committed a mistake in the matter due to his inexperience with the line of work he was at the relevant point of time required to discharge. Mr. Sharma submits that the said plea is not tenable inasmuch as the petitioner had spent a considerable number of years in the services of the bank at various levels and was in the know-how of the manner in which he was to discharge his duties. Mr. Sharma submits that the petitioner, senior counsel for the petitioner, had contended that the petitioner was not furnished with the requisite documents relied upon by the petitioner, relied upon by the prosecution, by the department for establishing the charges against the petitioner in the inquiry. He, by drawing this attention to the inquiry report, submits that therein it is recorded by the inquiry officer that the petitioner had informed him that he had received all management documents and had inspected all those documents, and it is only thereafter that the inquiry officer had further proceeded with the inquiry. Mr. Das submits that the petitioner had never approached the departmental authorities. This approached the inquiry officer and or the disciplinary authority with praying for being furnished with any document relied upon by the prosecution, a copy of which was not furnished to him and or not permitted to be inspected by him. Accordingly, he submits that the said plea of the learned counsel, senior counsel for the petitioner, would not mandate an acceptance from this court. Mr. Sharma has thereafter referred to, by referring to the further submission made by the learned senior counsel, that the departmental proceeding having ended after holding a sitting for 2 days, the petitioner was denied an opportunity to place on record departmental witnesses as well as defense witnesses as well as defense documents. Mr. Sharma, by referring to the inquiry report, has again submitted that on the presenting officer closing his evidence, the petitioner was given an opportunity to adduce defense witnesses and documents. He submits that the petitioner, in pursuance to the liberty granted to him, had examined himself as DW1 and had also produced defense documents. First off, he submits that even the petitioner was cross-examined by the presenting officer in the matter. Mr. Sharma submits that at the time of the inquiry, the petitioner had not raised any objection to the closure of the inquiry, inasmuch as he had by that time adduced his own evidence as well as brought on record 2 documents marked as DE Naoroba 4X-1 and DE 4X-2. So accordingly, he submits, Mr. Sharma submits that the set plea of the petition would also not mandate a consideration on merits by this court, would not mandate an acceptance by this court. Mr. Sharma submits that a perusal of the inquiry report would go to reveal that the inquiry officer had duly considered therein all admissible evidences coming on record during the inquiry and thereafter had proceeded to draw his conclusions in the matter. Mr. Sharma submits that the said conclusions being so based on admissible evidence, the same would not mandate an interference from this court. He submits that the said conclusions are also cannot be held to be perverse. Accordingly, he submits that this court would not act as an appellate court in the matter and proceed to shift the evidences brought, the evidences relied upon by the inquiry officer. He submits that the petitioner in the present petition has also not alleged that there was that the conclusions drawn by the inquiry officer was so drawn bereft of any evidence coming on record. Having made the said submissions, Mr. Sharma has submitted that the petitioner was an officer of the respondent number 1 bank and accordingly being a banker, the trust that the level, the responsibility required to be discharged by him in his works is at a higher stage. He submits that on account of the establishment of the allegations leveled against the petitioner in the writ petition, in the articles of charge during the inquiry, a loss of confidence of the bank upon the petitioner had occasion, and accordingly, the bank having lost its confidence on the petitioner, the penalty of dismissal from service cannot be held to be disproportionate. So accordingly, he submits that the present petition would mandate to be dismissed in limine. Anything more to be added?
My lord, only I am pointing out, my lord, this Annex 3, Annex 7, my lord, page 58, my lord. That is the appeal purpose.
Page
58, my lord.
58, yes.
Last 2 paragraph, my lord.
Yes.
I have joined
This is
that
the end
bank
of the
on-
matter, Mr. Das. Once you say this,
My lord.
you are admitting to the charges and you have given a letter to that effect.
My lord.
And that letter has been quoted by the inquiry officer in the inquiry report. And that letter, Mr. Das, unfortunately is on record also.
In my lord, this annexure 1 series, my lord, that is the letter of appreciation, my lord.
No,
Their
that
bank
is
was
true.
aware.
That is true.
That's-
That is
my lord.
true.
That was not at all considered, my lord. And even this appeal is still that has not been disposed of, my lord, till now, my lord.
Huh?
That has not been disposed of, my lord.
Appeal not disposed of. I've seen that letter somewhere. It is quoted in the what do you call that, inquiry report also. Page 92.
Thank you.
नीलकंठ से क्या बोले जाए मोरा charges.
Annexure 13, my lord.
Hmm?
Annexure 13.
Page 190.
Yes, 92. my lord.
92.
92 is the annexure 13, my lord, up to the
This
revision.
inquiry report last, but one penultimate page of that inquiry.
If it come.
Mr. Sharma.
Yes, sir.
One clarification. What about he says that he had refunded whatever amount was defaulted. Then why the further amount you are trying to recover from his gratuity and PF?
That I have to take care of, sir.
It's there. It's there. Orders are there. You have
There
not
should
said
be some
anything.
pending, otherwise there cannot be any question that gratuity or pension will be held.
Huh?
There should be some pending because otherwise the department cannot do that.
Hmm. You come to page 91. Because whatever is, you have the inquiry officer has not quantified any amount.
Yes, that has not been quantified.
Not even quantified. You have not even quantified any amount in your this notice at page 90. If that be so,
Then
how
gratuity
can
cannot
this,
hold your,
huh?
then gratuity cannot be held.
This gratuity as well as PF cannot be withheld.
Yes.
So give it back to him. We were not interfering with the penalty, but this gratuity and the
PF amount,
you give it back.
In the event of refund of the entire.
Huh?
In the event of refund of the entire amount which has been received.
The entire amount you have not quantified, we will not permit you.
Yes.
He says that he has given some money.
Yes.
That is enough.
Yes.
Now this amount, give it back to him with interest from the date it was bank norms interest with FD interest with effect from the date it was pending.
That might reach page 19, my lord. 6,70,260 that has been debited from his SB account, my lord. Page 19, my lord.
No, whatever has been debited, that has been debited. But this gratuity and provident fund, you will have to get back.
Yes.
We'll give you back that along with interest at bank norms from the date it was due to you. But we are not interfering with your termination. Disposed of.
Obliged to lord.
ಅವರ ಕಂಪ್ಯೂಟರ್ ಹೇಗೆ ಕವರ್ చేశారు ಸರ್ ಡಿಲೀಟ್ ಕಂಪ್ಯೂಟರ್ ಅವರು ಡಿಸ್ಪೋಸ್ ಅವ್ರಿಗೆ ವಾಸನೆ
Sorry, 30.
Oh,
My apologies, Lordship. My senior is not well, so although he wanted to come, he could not come.
This is, madam, unfair to the
Yes,
petitioner.
Lordship, I'm really sorry.
If she is unwell, he is unwell. You could have told him, he would have gone on. Mr. Sharma has,
Lordship.
not only here, he has other
Yes, yes.
other places also he
No,
goes.
Lordship, senior,
The
he said
courts
that
also.
if he feels better, he will come. He wanted to come
No, I
for
can't
this
keep
matter.
on waiting now.
Lordship, now.
This is doing this service to you.
Lordship, I'm really sorry. Lordship, just our one submission would be recorded.
Shall I dispose it off?
Lordship, Lordship.
But Mr. M.K. Sharma, learned counsel, appearing, learned counsel for the review petitioner. Also heard Ms.
S. Kemprai, Lordship.
S. Kemprai, learned standing counsel appearing, learned standing counsel KAAC appearing for the who is appearing for the respondent number 2, 3, and 4. None has appeared for the respondent number 1. So the petitioner in the present petition has, Mr. Sharma, please have a seat. Has prayed for a review of the order dated
T125, my lord.
P1 2025 passed by this court in WPC number 7045/2024. So I to listen down.
I want to.
Hey, to live streaming.